Mr. Sharma,
Yes, my lord.
just give back that record.
Yes.
Record. Yes, Dr. Goswami. This notification doesn't help you. In fact, it only shows that the constitution of the committee is not in accordance with 8C.
Yes, my lord.
This notification doesn't help you. In fact, it only shows that the 8C was not complied with.
My lord, in this case, HC has been complied, my lord. The members of the selection committee, my lord, it has been constituted as per rule, my lord. My lord, 8(4), it has stated in the rule that a selection committee, 8(4) of that 2003 rules, my lord.
Yes.
Selection committee shall be as follows. Firstly, the president of the managing committee. Only because in this case, my lord, president of the managing committee was not present, my lord. He was absent. Why he was absent? It was stated in the affidavit, my lord. The other person, headmaster of the school, he was present. One parent to be nominated by the managing committee, it was also present. And objection is that one expert was present. The petitioner objected the presence of the expert, because the expert was a relative of the selected candidate, but it was substituted by another person. So my humble submission is that the select committee was constituted as per rule.
No, you see, this expert in that 8(4), is in addition to above, there shall be a subject expert in case of selection of the post of selection of postgraduate teacher and graduate teacher. So this is not applicable for this typist.
My lord, wherever necessary, my lord. That word is there, my lord.
No, wherever necessary leads to, it must be read adjacent generis with postgraduate teacher and graduate teacher. Because
My lord.
this is limitation. This is not. I don't find this has an expanding meaning can be given to it.
Graduate teacher, postgraduate teacher and graduate teacher. And wherever necessary, my humble submission is in case of computer expert. It has been, he has been selected as a member of the selection committee. Just because the computer expert is not, may not be available in the other members. My lord. My lord, so it is a.
In this regard, my lord, one office memorandum is also there, my lord.
Yes. Okay, good.
No, there's one by engaging expert. Expert of them.
ঠিক আছে
Typist. Method of conduct.
My lord, it's serial number 7, my lord.
Yes,
Method of conducting typing test, my lord.
yes.
Type test shall be conducted at the district headquarters by the appointing authority by taking assistance of principal ITI or if not available in a higher secondary school by engaging experts, my lord. Here in this case, the computer expert has been engaged, my lord. And moreover, my lord, in their annexure 5 and 7. It will be clear from their own annexures, my lord. Annexure 5 and 7. Five at page 24, my lord.
Yes.
In the last paragraph. Who the public order is notified, satisfied, not satisfied with this result since it has been totally carried out through the corrupt practice and pray to your honor to reconduct the computer test viva under the strong interference of so and so. So computer and viva. And next annexure 7. At page 28. Second paragraph, your good self is intimated that due to adoption of corrupt practice by the school authority during the aforesaid test, a complaint was submitted to the inspector of schools, Punitpur. On this basis of this complaint, the inspector of schools reconducted the computer test as per rules, madam. He himself stated that as per rules. And he prayed for next page, my lord. Your good self is requested to do justice by reconducting the oral interview. Only oral interview. So it is widely covered by the modern law's case, my lord.
What is the citation?
My lord. Nineteen 3 SCC, page 486.
Nineteen
3 SCC,
Yes.
page 486. Here in this case also, Bhairavaji case was test was challenged. The locus standi to impugn on the ground of unfairness of interview process or defects in the constitution of selection committee. Held not possessed by the unsuccessful candidate who had taken a chance to get themselves selected at the impugned interview. My lord, in this case, the petitioner appeared twice, my lord. And after unsuccessful in the second attempt also, he has filed this petition. My lord, this small submission, my lord. The test was conducted in different schools, not in the present school. The post vacant in the Dakargaon High School, and the examination was held in Tezpur Government High School under the supervision of a headmaster of another school, Holester High School, and also under the supervision of the concerned inspector.
It was held where? Tejpur?
Tezpur Higher Secondary School, Gov Higher Secondary School. Is 16, my lord, of my affidavit.
Under supervision of? Under supervision of?
Under supervision of the S.K. Setri, headmaster of Holester Higher Secondary School. That too under the direction of the concerned DC, my lord. It was reconducted. So my humble submission is that the petitioner was, the respondent number 9 was selected as per rule.
You have anything more to add?
No, my lord, just that, my lord, it seems that the whole selection process, it was so arranged to favor a particular candidate who was related to the president of the managing committee of the school. He himself did not participate. He included one person who had no connection with the school. And then he included a subject expert, and viva voce test was taken when it was not required. And my lord, the selection committee ought to have been constituted of 4 people, but this selection committee was constituted of 5 members. And there was no delay in the complaint, my lord. The first written test was held on 19/1/2006. Personal interview and computer typing test was held on 22nd January 2016. And the first complaint was made on 30th January 2016. After which again the computer test and oral interview were taken on 3/2/2016. Also, the select list was not published at that time.
This person is a relative of president.
Yes, my lord.
What is the relationship of the relative with the president?
He seemed to be a nephew, my lord.
Nephew. Oh,
My lord, that relationship with the president of the GB, not with the president of the select committee. President of the select committee is defined, my lord.
Ms. Amit, just give me the dates you had said earlier. First interview on, first test on.
First test was held on 19/1/2016. That was the first written test, my lord.
Yes.
Then personal interview and computer typing test were held on 22nd/1/2016.
Which date?
22/1/2016.
22/1. And second test?
And the second test, my lord, the written test was not held again. Only the oral interview and computer typing, that was held on 3/2/2016.
Okay. Okay, let's just go through the records and pass orders. To be released today.
I'm sorry, my lord.
No, it's okay. No, I just. Yes.
But, which is already submitted, my lord, I'll not take your loss.
Okay, I'll go through the records and so they have produced a copy of that circular. And then office memorandum.
Regarding reconstitution of the, my lord, selection committee, perhaps.
Yes. This is it. You can just okay. Mr. Chaudhary, if you want, you can go through it.
No,
You
my
can
lord,
address
my
it
only
later.
suggestion is that these guidelines, my lord, your worship will kindly see whether it is contrary to the rules, my lord, because they cannot supplant with my lord notification regarding the constitution of the matter. That is the only submission I'll have. It has to be strictly in terms of the rules. If there is any violation, my lord, that is the only thing that needs to be considered by your lordship. I'll not take any other question.
And go through it and pass orders, it will be very smooth. And Mr. Sharma, any submission on that last against the last submission of Mr. Chaudhary? That by notification, the rules can't be supplanted.
So my lord, the interview and the viva was held as per rules, my lord.
Obliged.
My lord, the matter regarding correction of date of birth. I think, my lord, the petitioner has already retired from his service, my lord.
Yes,
Because, my lord,
that's
at
what
the time of filing this writ petition, my lord, his age was 58 years.
So he would have gone by now.
Right.
Okay. None appears on call for the petitioner. Mr. A. Kukan, standing counsel for the Elementary Education Department, appearing for respondent numbers 1 to 5, 1, 2, 4, 5, and 6. And Mr. D.K. Roy, standing counsel for the respondent number 3 are present.
3, my lord.
Next. The learned standing counsel for the respondent number 3 has submitted that this writ petition was filed for correction of the age of birth of the petitioner. So it is submitted that on 1/11/2017, when the affidavit was sworn by the petitioner, he was 58 years of age. Therefore, he has superannuated by now, and therefore the matter is infructuous. Next, be that as it may, as the petitioner is absent from cause, and the matter was listed on 23/9/2022. And the petitioner is also unrepresented when the matter is called today. What is of the considered opinion that the petitioner is not interested to pursue this read petition accordingly this, read petitions and dismissal for non-prosecution.
Obviously.
My lord, our names are not shown, my lord, reflected.
Is there?
It was like wildlife protection. It doesn't show like that. This is special PP wildlife, otherwise, or now is SC forest. My lord.
Oh, that is okay.
Yes, sir.
Yeah.
That led to the confusion, my lord. My lord had to.
You are ready with the matter?
My lord, this is a once rejected bill.
Hmm.
I had read over. My lord, this is a 90 days offense. I had to give instruction either charge sheet has been filed or not. My lord. Limited period.
Day after tomorrow,
Yes, ma'am.
okay. On the prayer made by Mr. D. Gogan and standing also for wildlife, the matter stands adjourned today to enable him to obtain instructions. List on.
Publish, ma'am.
My previous one.
Yes,
Lordship, in this matter,
Matter was for-
regarding this, whether the petitioner falls under the new pension scheme or the old pension scheme, there was a, my lord, matter on last Friday, my lord, the series of cases regarding this NPS and all has been, a judgment has been given, my lord, where 4 categories had been made, my lord, regarding ad hoc, OBB 7066 and my lord, drop teachers who are not in the category. Whether the petitioner is a stipendary teacher, then the petitioner is entitled. So that therefore, my lord, the judgment is not yet out, my lord. Can we fix after some time? Then we can, my lord, produce the whether we can tally the thing, my lord, whether the judgment.
okay. The petitioner here claims that he was appointed as assistant teacher. Doesn't say is stipendary.
On the last, Lordship will kindly see the order dated 15/12/2020, the last order.
Okay, we'll take it up at 2 then. We'll
But
take it up at 2.
the order is not online, we'll leave the order. On Friday only it has batch of
My lord,
series of
Last
cases.
time order was given for filing affidavit in opposition.
Oh, once the matter has been decided, there is no requirement of an affidavit.
That's why, my lord.
At
And
2 o'clock.
Friday it was, my lord, Friday it was the judgment was given.
It's
But-
okay. See, if by afternoon it is not uploaded, then we'll adjourn the matter.
Right.
But they have to
My
do
lord.
it
They at 2 p.m.
at 2.
Okay.
Right.
Just let him find out if the order is online.
My lord.
My privilege. This petition, they have, the petitioner has filed this petition lordship apprehending that since they do not have the DED qualification, the respondent may take worship action. Lordship has already heard this matter and I got a past order in WPC number 1334 of the 2018 lordship on 29/3/2023.
133.
4. WPC 1334 of the 2018. Nazrul Islam and 22 others versus State of Assam and others. The petitioners are appointed prior to 2/3/9/2021
Okay.
in terms with the amendment lordship.
Lordship, this is the instruction which I received from the department. You know.
So it will not be applicable.
My lord.
In his case, it will not be applicable.
My lord.
It will take a little for the petitioner. We'll get this order. WPC 1334 of 2018.
Yes, sir. Nazrul Islam and 22 others versus State of Assam. It has passed order on 29/3/2020.
29/3.
Yes, but order is not uploaded.
Okay, so same.
Yes. Obviously.
Significant for the
Elementary
elementary
education.
education department.
Quickly, please.
This was-
Waiting, your lordship.
Yes.
The matter has become infructuous, your lordship.
This matter.
Item
Also, they duly represented. Mr.
As Gautam.
As Gautam and counsel for the petitioners. Submit that the matter has become infructuous. So accordingly, this representation stands for having been rendered infructuous.
Please, your lordship. My lord, the petitioner wants to withdraw this case, my lord.
Upon instructions, both sides are represented. Upon instructions, Mr.
AK Das, my lord.
A.K. Das, appearing on behalf of the learned counsel of the petitioners. Submits that he has instructions to withdraw this petition. Accordingly, this petition stands dismissed and withdrawn.
May it please, your lordships.
Yes.
Lordship, I appear for the nearest in this matter, this the respondents. But can it be taken up at 2, my lord? My senior has some difficulty now. So,
At 2, there'll be some difficulty, lordship. But that is peculiar development in this matter, lordship. I asked, bless it. There was some technical error in filing this petition. It ought to have been filed at Itanova bench. The last time the matter came up, the respondents counsel, learned counsel responded, vehemently objected to that, alleging that we have suppressed the material facts, that it is by due time we have filed it here. The honorable judge, who taking the matter, also expressed the desire that we should file the proper administrative application. Mummy has to maintain the case here. So unfortunately, there was some delay. We filed this application before the Honorable Chief Justice for the register on 30th of March 2003. And it's likely to be some order is likely to be passed. May I-
But you say this matter has become infructuous after the age of 62.
Lordship.
Even if you refile it before that court, what would happen?
yes, lord, exactly.
Can you get any relief?
Yes, lordship, that there are 3 distinct prayers in this matter. If I may show you, one prayer that always challengeable, lordship. Therefore, lordship, page, turn to page. Prayer. Lordship, page 28
Yes.
of the petition. The first prayer is that mandamus or any other appropriate read order direction should not be issued directing the respondents to cancel, recall the impugn retirement order. So that is, of course, lordship will decide whether this being infructuous. I don't have any objection. Prayer number 2, lordship will kindly see. And in the alternatives, your lordship will be pleased to declare the impugn orders dated 1/5/2018 and 12/2 as illegal and null and void, and be pleased to set aside and quash. When an order was passed, I have challenged the legality of the order. May what happened, if time may be passed off, whatever it is. The legality of that prayer, that is not,
That will
it
be
will never
different.
become infructuous, lordship.
Mr. Kakari, that will always be academic interest. If you don't, if your extension doesn't survive,
Lordship,
then why would you enter into that 12C?
no, if this order is held to be illegal, wrongly passed, I will be definitely entitled to some consequential benefits. I may claim or may not claim it, but I may claim or may not claim, but if the order is held to be illegal order, that has deprived me 2 years of my precious service period, I'll be definitely entitled to some consequential benefits. Therefore, this part of order, Lordship, will always remain.
Well, that order has suspended its force right now. So
Then, third prayer, Lordship, opposed to allow the petitioner
There is
to
no meaning
continue
in
as
doing it.
successors, that is becoming infructuous. First prayer, first part of the prayer, all of these things, that will be infructuous. But the second prayer, in the alternative, that impugn order will be declared as illegal, will be set aside and quashed. That legality or illegality of this order, first prayer would always open to be questioned. That would not become infructuous. Many times like this special orders are selling, the man completed the year of service. After that, it is held that order was illegal. Then he'd be entitled to some benefits if he wants. So this part, second prayer, is absolutely independent. So therefore, the scope to examine the petition will always remain. Even if I give up the first, second continues. There are 8 of this petition, Lordship. Moved but honorable chief justice may be looked into, Lordship.
No, I will not be impressed with this because of the fact that on 29th I passed an order, it will not be adjourned.
No, and your Lordship, I have no objection, the matter is taken up, but this petition also pending before the honorable chief justice for.
No, it is not because the file is before me.
So it will be all better the chief justice 2 or 3 days time, you will be given, meanwhile this petition shall be disposed of.
And my lords will take note of the fact the matter is pending since 2018 and they have filed an application now in 2023. When the matter is infructuous.
That is for not me to decide.
In any case, my lords, that even if my lords decides this impugn orders to be illegal, he cannot be reinstated now. So there is no point in adjudicating the matter before the matter.
No, he gets the financial benefit. Assuming that it is right. His
Because,
attempt to continuation
He has not
62
prayed for that in the writ petition. Lord. If Malas will see the prayer, he is not seeking any financial benefits.
No, that is a consequential benefit. He will get it. Even if he does not pray, he'll get that relief. If once he is in service, can you say that I am not paying the salary?
Sir, I understand. But if my lords is hearing the matter, can it be taken up after some time, my lords?
Adjourned when there is moved the honorable chief justice, then I will not preclude the honorable chief justice to decide the matter. That it go before him. Mr. R.P. Kaguti, the senior counsel, has produced a copy of letter dated 30/3/2023 addressed to the honorable judicial justice for transfer of this matter. Also for
Not transfer.
No,
I
for
think the
retention
letter
of
should be
this.
retained here.
At
That's
this-
not prayer.
at the principal seat. No, if your prayer is for retention at the principal seat, then you can make your argument. Then why should it be adjourned?
No, because that was the honorable seniors who took up the matter. We expect the DGID I should file a petition for administrative. Because matter pertains to Itanagar banks. I assured the honorable court.
Which date is that order?
No, that is verbal order. How will it was?
No,
The
no,
learned friend, opinion, the respondent strongly objected.
no, that is okay, but
There was no such order.
So I
in
have
the session.
assured the honorable court. That's why I have
Once it-
filed it.
once that order is not there,
The order is not is verbally.
then you
Is it
can
up to him,
start-
taking the.
then you can start the hearing. If your prayer is to take it up in this bench, in this seat, then you will start your hearing.
That's the logic. Yes.
Start it. Yes.
Can I be accommodated for some time, my lords?
No, since I've started the hearing, I will take it up.
If my lord takes it up over 15 to 20 minutes, my lord,
I think Mr. Kakati will take 15 minutes. You can come by the time and it will. Yes,
Lordship. The petitioner is a qualified person who was appointed as a registrar of NEDIS on 30th of November 2012, Lordship, after completing the selection process successfully.
what is the date?
30/11/2012. 30th of November 2012.
Appointed us.
As a registrar of NEDIS, Lordship. NEDIS is Northeast, Lordship, NEDIS.
Yes.
Northeastern Regional Institute of Science and Technology, Itanagar, Lordship.
Yes.
Now, on Lordship, that 31st of May 2005, the government of India declared NEDIS as a deemed to be university under Section 3 of the EGC Act, which you will find it page 39 of the petition, Lordship. Page 39 of the petition.
Yes.
Page 39. In Lordship, what it is.
Yes.
In exercise of the powers conferred by Section 3 of the UGC Act 1956, the central government, on the advice of University Grants Commission, hereby declares the Northeastern Regional Institute of Science and Technology, Itanagar, Arunachal Pradesh, as deemed to be university for the purpose of the aforesaid act, with immediate effect subject to the following conditions. Number one, the institute will adhere to the guidelines, instructions issued by UGC and other concerned statutory bodies from time to time as applicable to the deemed universities. So, now I will place under UGC, Lordship. Now, the 71st meeting of the Board of Management and 85th meeting of the Board of Management, the UGC had some amendments to their policies. We have adopted, we shall follow the UGC's amendments because we are placed under UGC. Now, what is the recruitment rules for appointment of the staff in the NEDIS was also passed, Lordship, at page 45, Lordship. The recruitment rule 2014 and page 47, Lordship, may kindly see. Name of the post registered. And at the end of the column, remarks, age of superannuation shall be 62 years. This deed was framed by them. It was sent to the ministry for approval. Ministry has not yet approved. That's a different question. Now we'll come to that. Now, Lordship, on on the sixth pay Central Commission report recommendation, Lordship. That was issued on 31st. A letter was issued to the Secretary University Grant Commission on 31st of December 2008 at page 50, Lordship. I am directed to say following revision of pay scales of the central government employees in pursuant to the recommendation of the sixth pay commission. The Minister of Finance and such. Now, I'm in the other line, Lordship, subsequent line. Taking the relevant factors into consideration, it has been decided by the central government to revise the pay scales of the officers of the universities and deemed to be universities fully funded by the central government. That is our NEDIS, like NEDIS and others, which are fully funded by the government. Namely, such and such, namely registers, deputy registers, assistant registers, controllers of examination, deputy controllers of examination, etc., etc. Deputy finance officers, as mentioned below. The revision of pay scales, etc., shall be subject to the various provisions as contained herein and regulations to be framed by the UGC in this behalf. Now, below that, Lordship, that the sub clause 1, register, finance officer, controller, Lordship, chapter 1, A, B, C, and the C in the next page, 51, Lordship.
Yes.
The age of superannuation as at present shall continue to be 62 years for the register and equivalent posts. While this recommendation has been accepted by the NEDIS as the director of central government, recommendation says the age of registered superannuation age is 62 years. That was being followed, and accordingly all payment benefits were received. Now, thereafter, Lordship, the seventh pay commission has come into existence, and by later date at page 55. The seventh pay commission.
The earlier was sixth.
I got a sixth, Lordship. This is on, that was in 2008. This is on 2nd November 2017. Issued. I am directed to say that following revision of pay scales, same language, Lordship, central government employees on recommendation of the seventh Central Pay Commission, the Ministry of Finance has issued guidelines regarding the pay revision of employees of quasi-judicial organizations, autonomous organizations, statutory bodies, etc., set up and founded and controlled by central government, by such and such. The central government has decided to revise the pay scales of the officers as given in the subject mentioned above of the central universities and centrally funded deemed to be universities. That is, one of them is NEDIS. The revision of pay scales subject to the various provisions as contained herein, the regulations to be framed by UGC in this behalf. That is number 1, para number 1, Lordship, Roman 1, Roman 2, and Roman 4 in the next page, Lordship. The age of superannuation as at present, that means as at present, shall continue to be 62 years of the register for register and some other officers. So after this also, the age of the superannuation of register continue to be 62 years. But we are kindly turn to page 63. Thereafter, Lordship, the petitioner, page 63, by order dated 20th April 2018, petitioners, Lordship, that has availed some earned leave, and he was also sent on duties. That way, from what is the register will be out of station on official tour and earned leave from 9/4/18 forenoon to 30/4/18. I was granted earned leave. I have also entered some official duties up to 30th of April 2018. And on completion of the earned leave project on 1st of May 2018, I have joined back I work for the whole day. And at 6:30 in the evening, when I complete my works, I have to sign my checks also for the institute. A letter was served upon me. Lordship will kindly say, page 16, 64, annexure 12A. That is 1st of May, Lordship.
Yes.
Lordship. At about 6:30 PM, Lordship, when I was about to go, an order was served upon me, Lordship, by the Director Nearest, in compliance of MHRD later dated such 1518. Dr. R.P. Bhattacharya, Register Nearest, has superannuated on 34/18, earlier day, have superannuated earlier day. That was served upon me on 1st of May. Hence, in exercise of the powers conferred under clause such MOA, Director Nearest hereby directs Sri M.K. Kamdar, Deputy Registrar, to take over the charge of Register Nearest in addition to his own duties. Also, we never heard of such business. I was a number 2 in the university. I was a registrar. I completed more than 7-8 years from 12 to 18. Then I have come back. I have joined on 1st of May. I have done my works assigned to me. I was asked to sign some 6. I have signed it. 6:30 when I was about to go, this letter was served upon me that we have superannuated from service yesterday. And nothing else. Then directed the second man to take over the charge from me. Most unceremonious and unheard of manner, Lordship. Now, next page, page 65, it shows this letter from the was received from the officials of the ministry at 2:59 PM, that is at 3 PM on that day. The letter is Lordship, letter which they have received, which referred in the order, was supposed to have been, was stated to have been received from the ministry official. That letter was received on 1st of May at 3 PM. I was not allowed to know anything about it. I worked it on 6:30 PM. Then I have signed some checks also. Then it shows Lordship that 3 PM, so I was kept in total dark. Suddenly, when I'm closing down, going, then letter was served upon me. It appears there was a conspiracy, something like that, throw me out. Now, Lordship, I see that interim order, which is supposed to be issued by the ministry, at page 66.
Yes.
The order said like this: I am directed to refer to your later date such that means addressing to the director, and to state that post of Register Nearest is governed largely by the service condition under which the appointment of was made. As Dr. Bhattacharya, Register Nearest service condition is governed by CCS rules. He will retire at the age of 60. Further, Nearest is informed that the post of Register thus falling vacant will be filled on an interim basis in accordance with the provision given in MOA clause 15. As such, Nearest may immediately process for filling up the post of Register on a regular basis. However, the norms of the same as stipulated in AICTE guidelines need to be checked by the institute. If AICTE norms at present and present norms are at variance, AICTE norms will prevail. In case AICTE norms are not applicable for the, if not applicable for the post of Register, NIT norms available for the Register should be followed. NIT norms, Lordship. If follow either AICTE or NIT norms. In NIT norms, Lordship, the post of Register is up to 62 years. So therefore, now this order was issued, Lordship, by the Undersecretary of Government of India, and it says, actually, you follow the NIT rules. NIT rules is 62 years superannuation period. How it has become 60 years for register of merit. On the same day evening, Lordship, a release order was issued to me. Whereas Director Nedis issued the opinion that is on page 67. Within half an hour, served the order, release order was issued, asked me to get out. Page 67. Annex 12C. Nedis is opinion that in the public interest to do so, in view of MHRD letter number such. Now, therefore, in exercise of the powers conferred by Rules 56 of the Fundamental Rules as applicable to employees of NEDIS, the Director of NEDIS is pleased to order retirement of Dr. Ramapata Bhattacharjee registered on attaining the age of 60 years and his service stands released from the establishment of NEDIS with effect from afternoon of 30/4/2018. This is served on 1st of May. Then I filed a presentation that was denied, rejected. Now, Dr. Kindly to now again this order is supported by the learned counsel, the respondents, and what they have stated was with the affidavit of opposition. Firstly, Lordship, on the basis of affidavit of opposition at page start from page 83.
Yes.
Lordship. They supported the order on the basis of some document they have annexed. Lordship, you see kindly annex that fee, Lordship, at page 94.
Yes.
To directors centrally funded technical institutions. Revision of pay. Lordship, this is applicable to the centrally funded technical institutions which are not, Lordship, deemed to be universities. They are deemed to be universities or universities that are centrally funded, fully funded by the central government. There are other institutes like IITs, NITs, which are centrally funded. They are also centrally funded. The rules and regulations are different for deemed to be universities. In support of that imperial order, this document was placed. But this says this is exclusively meant for the fully centrally funded institutions, not deemed to be universities. Now, it's very clear this revision of pay of teaching and other staff centrally funded technical institutes following the pay revision of the central government employees on the recommendation of central pay commissions. To show that the centrally funded technical institutes and the centrally funded deemed to be universities, they stand in defined footings. Lordship may kindly turn to page that 7th pay commission or 6th pay commission that is on very clearly distinctly stated that, Lordship. Lordship may kindly turn to page 50 of my writ petition, Lordship, Annex 8A.
Yes.
But this pay recommendation is accepted for the whom, Lordship, that taking the relevant factors, first paragraph, Lordship, for the middle portion of reading, taking the relevant factors into the consideration, it has been decided by the central government to revise the pay scales of the officials with the universities and deemed to be universities fully funded by the central government. That is, one of them is NEDIS. So NEDIS stands in a defined footing because it's deemed to be universities. And other institutes like NITs, IITs, they stand in a defined footing because they are institutes. NEDIS is deemed to be universities. And this pay recommendation are made exclusively for the universities, centrally funded universities, and centrally funded deemed to be universities. They stand in defined footing, Lordship. Now, this document is annexed in Lordship. In the counter affidavit, Lordship, as Annex 3. This is applicable to the centrally funded institutes, fully funded institutes, not to the deemed to be university centrally funded. So this is not that no reliance can be placed in support to substantive impugn order, Lordship. Now, Lordship, time to page 99, Annexure 4. Of the Philippine opposition. Lordship. To justify throwing me out at the age of 60, this order was put up. Lordship, you can listen. Framing recruitment rules for non-teaching posts. I am directed to refer to the subject cited above and to state that MHRD has observed CFTS have either not framed recruitment rules RR for its non-teaching posts, or the same is not as per latest AICT Government of India guidelines. It is therefore decided that CFTIs may frame RR's recruitment rules for all the non-teaching posts such as register, deputy register, if not framed earlier, as per latest AICT Government of India guidelines, and get the same approved by BOG immediately before initiating any regular basis. So this is exclusively meant for centrally funded institutes, Lordship, not deemed to be university central funded. And this was issued.
I don't, and the top, it is written, it is addressed to you, the rest.
It is that Nedis, Lordship. Direct. Nedis turnover. Framing of recruitment rules, there is such thing to framing recruitment rules. But it is therefore decided to such this is issued by whom? Not a section officer of the ministry. The lowest bottom section officer cannot complete any board. If it should be, but institute like ladies, they due to be universities, cannot act upon the order of the central section officer. Relying upon this letter issued by the section officer to damage the EA and for CFTAs and not for deemed to be universities. This letter was issued by one section officer, authenticity or the Lordship will kindly judge. It is though it is addressed to Nedis. Nedis is not a centrally fully funded institutes. It's deemed to be universities that will be recognized. So to rely upon this order is very dangerous. This is not meant for deemed to be universities centrally funded. This is meant for centrally funded technical institutes. Now, next parallel, next page, which was also put up by responding institute to justify my impugn order at page 100. Got it. This is issued by
Just a moment.
Lordship. Lordship.
Yes.
Not Lordship. Page 100, Lordship, this was issued by, again, Ministry Deputy Secretary, but this letter has been greatly relied upon the respondent to justify the impugn order. I'm reading that order, Lordship. Subject, minutes of 89 meeting Board of Management Nedis held on such and such date. I am directed to refer to the minutes of 89 meeting of the Board of Management Nedis held on 27 March 2018 at MHRD Sastri Bhavan, New Delhi, and to inform that with respect to the agenda item of 89.03, the opinion of JSMHRD was that the recruitment in Nedis should be done based on AICTE norm and not UGC because its deemed university status is only for degree awarding purpose. It was pointed out in the meeting that as per Supreme Court direction in the case of 2017, SC has made it clear that the deemed university cannot be considered as a conventional university. Last line, very important, Lordship. In any case, since NERIS follows AICTE norms for sanction strength of its staff, the AICTE norms for recruitment of faculty must be followed. Lordship, kindly. This line very clearly states that AICTE norms should be followed only for the appointment of the faculties, teaching staff, not for non-teaching staff. Because AICTE, they prepare the syllabus and curriculums of the engineering courses. To that extent, they determine the courses and everything. And this letter was meant only for the faculties of the NERIST, not for me, I am registered, or any non-teaching staff.
Yes.
Must emphasis was placed on this letter, but this is meant for only faculty, not for us. It's almost, it amounts to misleading the Honorable Court. Now, let's may kindly turn to Annexure 8. Page 103. This is also put up to support the interim order issued on 1/5/18. I'm reading that order, Lordship. Clarification regarding guidance issued by AICTE regarding. Second paragraph I'm reading. Further, NERIS is informed that post of register does falling vacant will be filled on interim basis in accordance with the provisions given in MOA clause 15. As such, NERIS may immediately process for filling the post of register on a regular basis. However, the norms for same as stipulated in AICTE guidelines need to be checked by the institute. They are not sure, Roger. If AICTE norms and present norms are at variance, AICTE norms will prevail. In case AICTE norms are not available for the post of register, NIT norms available for the register should be followed.
This is already read in the.
I will visit that in the technical voice also this letter. And it clearly says that NIT, but that we should follow the NIT rules. But NIT rules says the age of superannuation of the registrar is 62 years. How they have got it from 6 years, it is not known. Now, Annexure 9, Lordship. This was issued by a section officer. I'm issued to the director NERIST. The second paragraph I'm reading, Lordship. It is therefore decided that CFTIs, the CFTIs only for centrally fully funded institutes, technical institutes, Lordship, as may frame others recruits for all the non-teaching posts, such as registered, deputy registered, if not framed earlier.
This is same thing as page
Same
99.
thing, Lordship,
Same.
as approved by BOJ, such as initiating the recruitment process. This is also meant for only centrally fully funded technical institute, not for deemed to be universities. So these documents, none of these documents can help the respondents to justify the interim order or interim order passed by them. Now, in reply to that, Lordship, kindly I'll take your Lordship to some annexes have documents have annexed my Lordship. Affidavit in reply. But they kindly turn to our affidavit in reply, Lordship. at page 134. Annexure 18B, Lordship. I have made an RTI application to the ministry, Lordship. What is the superannuation age of registered finance officer, controller, examination of a university oblique deemed to be university? That RTI application I made to the government of India, Ministry of India. Now, this it was forwarded by the ministry. It was forwarded to the EGC Secretary University at page 23, at page 134. Lordship. It was sent by the Undersecretary to the Secretary, University Grants Commission. Information under RTI Act. I am forwarding herewith a copy of the RTI application dated 17/4/2019 of Sri Ramapada Bhattacharjee, Assam, on the subject mentioned above. Since the information sought by the applicant may be available with EGC, the same is transferred to EGC under Section 60 of RTI Act for providing the requisite information to the applicant directly under intimation to this ministry. Now, next page, Lordship. While it was forwarded to the EGC, EGC has given a reply to me on behalf of the ministry. And next page, Lordship. The question is, what is the superannuation age of registered financial or deemed to be universities? The reply, Lordship, they have not given a specific reply. A copy of the MSID notification dated such and such 31/12/81 is enclosed. That means all replies that were seeking, it will be there. This is that letter which has come, Lordship, present before Lordship, that while adopting the 6th pay commission, the letter issued by the ministry for adopting 6th pay commission for NARIS, that was the letter which was put up to us, which I have already placed, Lordship, before Lordship, that in my annex in my writ petition, Lordship.
Yes.
So that is the only answer. Ministry has sent it to the EGC. EGC, while giving me the answer,
That is page 50 of your writ petition.
Lordship.
Same thing.
Yes, same thing. They have forwarded this to me. That means this is the answer. Answer you will find here. Answer is that age of superannuation register is 62 years.
Yes.
Lordship. Will you kindly turn to page 135, the same thing, Lordship. This is page 136, Lordship, that it is established that now page 141, Lordship, of the I have made a similar RTI application with UGC also, simultaneous to the government. They also, Lordship, that reply had come from UGC on August 19, Lordship, 16 August 19, at page 141. It has come from UGC. The question is, Lordship, may I read the question? What is the superannuation age of registered at St. Louis and Deemed universities? Now this time reply has come from UGC. Age of superannuation for the registered finance officer, controller of examination is 62 years. However, the new regulation for the post of registered cadre is under consideration of MSRD. Now, as I said at that time, it was 62 years. That is the reply of the UGC. Now, page 142. I put up a RT application to the nearest Director nearest Lordship.
Yes.
Lordship. This RT application I have put up to Chairman Nearest Lordship. And the reply has come. The question is there, Lordship will find it. Question number 1. Nearest is deemed to be university under section EGCX since 31/5/2005. During the period that is from 2005 to 2022, a large number of posts filled up, both direct or by promotion. Reply is yes. Second question, which recruitment rule was followed for filling up the post of nearest, like the post of registrar, deputy registrar, assistant registrar, net administration, technical officer, etc. During the period in question, that is 2005 to 2022, which recruitment rules you are following in appointing these posts?
Yes.
Lordship, that answer is from the institute it has come. Nearest recruitment rules and UGC norms. We have been preparing recruitment from 2005, 2014, etc. etc. These are not approved by the ministry, but we are following these recruitment rules. This 2014 recruitment rules, which says the superannuation age of register 62 years. When I pointed out to that, I was told that you are misleading the court because recruitment rule has not even been approved. But rules have been pending there from 2005 onwards, 1997 onwards of the list. Not being approved by the ministry, this is just fine, but we have been appointing because no alternative, we have been appointing under these rules. And rule 14 also applicable in this case, and as well as with the approval of EGC rules. So that 2014 recruitment rules, which I put up that age of superannuation is 62 years, that was also being followed. They admit it. Now, Lordship may turn to page, second page, Lordship, page 143.
Yes.
I put up the RT application to the nearest authority only. The question was, what is having recruitment rule, especially during 97, 2002, 2014, request to inform superannuation age of registered finance officer, controller, examination being deemed to be university. The answer has come. Ladies doesn't have the approved recruitment rules. The same recruitment rules of 97, 2002, 2014, all in draft stage, have been sent to the Ministry of India for approval, but till that there is no communication from Ministry. A copy of the reminder letter, but this is not much help. Yes, they said they are only admitting the fact that recruitment rules are pending there. Now, next page, Lordship, 144. The question is, that is again to the nearest. Question is, Lordship, specify the nearest recruitment rule operated for recruitment of promotion of all posts during 2005 to 2022. Now, look at the answer, Lordship. The first sentence is saying, second sentence of the answer, Lordship, pending approval by the ministry, nearest follows the draft recruitment rules 2002, 2009, 2014, and UGC guidelines for recruitment of the promotion of the all posts during 2005 to 2022 as approved in respect by respective BOMs, that is Board of Management's meeting time to time. So when I said that recruitment rule 14 says superannuation age is 62 and my serving after 62 is quite justified, then it was pointed out that this rule was not approved by the year, so it is not being taken. You cannot, it's almost a misleading step. But now NERIS itself admits the recruitment rules from 1997 onwards, all of you are doing it, pending in the minister, no reply has come. But in all appointments, you are following the same recruitment rules. So the 2014 recruitment rules, which is ongoing now, the post of superannuation of register, I have annexed it with petition also, is 62 weeks. I'm bound to serve up to 60 years. I cannot be cut short like that. No. Let me turn to page 145. This is the Board of Management's meeting, 90th meeting of the Board of Management. The relevant page is 149.
Just wait, I'll take a break and come back.
Ninetieth meeting of the Board of Management, Lordship.
Yes.
The relevant page, Lordship, that's page 149.
Yes.
I'll point out to Lordship only the resolution, the last part of the page, Lordship, resolution. The minutes of 89 BOM were approved with MHRD observation to follow, MH Ministry observation to follow AICTE norms for recruitment of faculty. The comments of the chairman BOM were seriously noted to avoid such practices in future. That means only for recruitment of faculties, AICTE norms will be followed. Otherwise, non-faculties, it is all the UTC rules and our own recruitment rules that have shown lots we have been following that only. Now, most interesting, lots may come to page 153 and excerpt 23. After my lots of the retirement, post was advertised. And on advertising number 1 of 21. And post to register, master degree holder, etc. And last line, Lordship. This post of register, Lordship, that the age of superannuation as at present shall continue to be 62 years. So my departure, this advertisement issued. Now, superannuation age of the register is 63 years. All along 63 years, suddenly in my case, Lordship, I was forcefully retired at the age of 60. And that was very unceremonious and unheard of practice in Lordship. So that's my submission, Lordship. I've placed before Lordships all the relevant documents to show, including recommendation of pay commissions, the register's superannuation age is 62 years. So it's the order passed by them based on the direction of the section officer. It's all motivated and planned up. That what it shows. And AICTE norms, they said AICTE norms to be followed only for faculties, teachings, because they regulate the syllabuses to course engineering courses. Nothing to do with my course, Lordship. So I humbly submit, Lordship, the MP order passed by them is absolutely illegal to be stuck of. And to be quashed. That's my submission. Deeply obliged.
The Lordship will first take up the writ petition.
Yes.
If your Lordship first, on the other day also I was pointing out, if your Lordship will come to the prayer, page 20. There are two prayers made in the writ petition. Your Lordship will find the first prayer is to set aside the order releasing him. And the second prayer which your Lordship will find in the next page, to allow him to continue to 62. And if your Lordship sees the affidavit, which your Lordship has already noted in your Lordship's last order, the date on which the writ petition was filed, he was already 60 years. And in fact, he has annexed his identity card, which is at page 31, that reflects the date of birth. So as on today, he is already 65. There are two relevant facts, madam. First is the very fact that he was serving as a registrar, which means he was all along aware of the executive instructions, of the communications between NERIST and the Union Ministry. However, what he does is very interesting. Your Lordship will just make a note of 2-3 dates. On 1/5/2018, he was released on attaining the age of 60. Your Lordship will just make a note of the dates. On
Yes.
1st of May 2018, he was released. Then, if your Lordship will kindly take up our affidavit. Before I take your Lordship to the merits of the case, I was just indicating the conduct of the petition. Whether your Lordship will at all entertain such a petitioner while exercising extraordinary powers. Page 25 of the affidavit in opposition filed by NERIST. Upon being released, he submitted a representation, which I'm sure the petitioner must have pointed out. And the representation was rejected. On being rejected, page 25, he sends this email that if you are not considering, release my retirement dues. If there is no favorable decision of my prayer to Chairman so-and-so, my pending checks may be deposited to SB account, please. So he is asking for the retirement benefits, which were paid on 25th of June 2018. Which your Lordship will find at page 26 of our affidavit. All his retirement dues were cleared, and he himself asked for it. And your Lordship will make a note of this date, 25th of June, which is reflected in page 26. His dues amounting to about 35 lakhs were released to him. And now your Lordship will look at the date on which the writ petition is filed. It is either in the end of August or in September. Now, in this context, your Lordship will look at the other factual aspect. Everyone is aware where NERIST is. It is in Arunachal, Nirjuli, Arunachal. The writ petition is filed here without even taking permission of the Honorable Chief Justice on the administrative side. The reason is because nearest has a standing counsel in Itanagar. The relevant facts would have come out. What was the, if your lordship sees the basis on which the interim order was first passed, what was pointed out simply was that these are the recruitment rules as per which retirement age is 62. It is not disclosed that these were merely draft rules. It has not been approved by the Union Ministry. Simply by making a submission that under these rules, retirement age is 62, he takes an interim order. That interim order was vacated when we filed an IA pointing out that these rules have not been approved. There are several lacuna in the rules. Therefore, it has not been approved. It has not been adopted. When this fact was brought to the notice of this honorable court, the interim order was vacated.
No,
So-
but this page 153,
My lord,
that is again 62. So why petition
that is,
should not be verified?
again, it has not been disclosed. He was the registrar. It has not been disclosed that this advertisement has not been given effect to. Till date, there is no, Neris is working without a regular registrar. That advertisement was not carried forward. That advertisement was issued. The petitioner is right to that extent. But there was a mistake. And therefore, this advertisement was never given effect. So, this is so far as the conduct of the writ petition is concerned. I'll take your lordship for a little further on the conduct. If your lordship will take up our affidavit and your lordship kindly turns to page 9. This is the minutes of the meeting of the Board of Management held in 84-85. If your lordship kindly turns to the next page, page 10. Adoption of rules. At serial number 1, FR and SR with amendment and government's decision thereon from time to time. And number 2, Central Civil Service Rules 1966. So as far back as in 84-85, the Board of Management had adopted these rules. So these are the rules that govern Nearest. This is again suppressed from your lordship. And if your lordship will kindly turn, that is why what gains significance is the fact that he was the registrar. He had access to all these documents. Your lordship will kindly turn to page 11.
Just a moment. Yes.
Now, in that meeting, Board of Management meeting, these rules are FRSR and CCR rules are adopted, and the relevant provision of the FRSR is annexed at page 11. at the very top, your lordship will find FR 56, small a.
Yes.
Retirement age is 60 years. Now, my lord, if your lordship kindly turns to the next page, page 12. A question is being sought to be raised that this is not a centrally funded technical institute. This letter is addressed to the director all centrally funded technical institutions. And at page 14, your lordship will find nearest is included. At para 4,
That is for director.
directors, as regards the directors of centrally funded technical institutes, it was decided to follow a two-tier structure as in the case of faculty positions as under. For subclause B, for directors of NITs, etc., and then your lordship will also find nearest.
Yes.
So it is not a case, not in dispute that nearest is a centrally funded technical institute.
No, that's okay, but this is for director, may not be applicable for the registrar. Because the submission of Mr. Kagote is that
Your lordship will kindly turn to page 16 of the same document.
16.
Page 6. Clause 9. For registrars. For registrars, deputy registrar, assistant registrar, UGC pay scales will apply to registrar, deputy registrar, assistant registrars of IITs, etc., and deemed to be universities, subject to they possessing the qualifications and experience as prescribed by UGC from time to time. For others, normal replacement scale as per CCS RP rules 2008 will apply. Age of superannuation will, however, continue to be 60 years. This is again a document which is not disclosed to your lordship in the writ petition. And he was the registrar himself. And he had access to these documents.
Yes.
Now, next page, page 17. This is again from the Ministry of Human Resources Development. Addressed to the director, second line, your lordship will find Neres Itanagar. And second paragraph of that. It is therefore decided that CFTIs may frame the RRs for all its non-teaching posts such as registrar and deputy registrar, if not framed earlier, as per latest AICTE / Government of India guidelines. And AICTE and Government of India guidelines says, and the rules say that it is 60 years. Now, next page again, my lord, page 18.
And still, Mr. Chaudhary, Mr. Kagote has made a strong point. Because if he is the registrar, the AICTE is applicable only for the teaching staff.
But otherwise, what has been adopted is, that is our stand. It is, since we have adopted the CCS, CCA rules and the FRSR, that prescribes 60 years. And it has been uniformly for the post of registrar, it has all along been 60 years. Now, we'll further clarify. If your lordship will kindly come to page 18.
Just a moment. Page.
Page 18 of the same.
Yes.
This is another letter addressed by the Ministry of Human Resource Development, Government of India, and it is addressed to Neris. So the 89th, my learned friend had placed before your lordship the minutes of the 89th meeting. With regard to that particular meeting, what the ministry had to say is reflected in this letter. This is addressed to the Director Neris. I am directed to refer to the minutes of the 89th meeting of Board of Management, Neris, held on 27 March 2018 at MHRD Sastri Bhavan, New Delhi, and to inform that with respect to agenda item number 89.03, the opinion of JS MHRD was that the recruitment in Neris should be done based on AICTE norms and not UGC, because its deemed university status is only for degree awarding purpose. It was pointed out in the meeting that as per Supreme Court directive in a case of 2017, Supreme Court has made it clear that a deemed university cannot be considered as a conventional university. In any case, since Neris follows AICTE norms for sanction strength of its staff, the AICTE norms for recruitment of faculty must also be followed. And accordingly, amendments were directed to be made to the 89th meeting minutes. Now, if your lordship will kindly come to page 21, it is not that we have whimsically released it. We are getting the entire funding from the Union Ministry. We are absolutely at their guidance. On 1st of May 2018, before we released him, this is what the ministry told us.
Which page?
Page 21.
Yes.
This is specific to the writ petition. This is again from the ministry to the director. I am directed to refer to your letter. We sought the advice of the ministry. I am directed to refer to your letter dated 24/2018 and to state that the post of registrar Neris is governed largely by the service conditions under which the appointment was made. As Dr. Bhattacharjee, Registrar Neris, service condition is governed by CCS rules. He will retire at the age of 60. And it is on the advice of the ministry that we released on him attaining the age of 60. And his appointment orders, the offer of appointment and the appointment order itself, if your lordship sees, we have made it clear that it will be, his service conditions will be governed by the central government rules. If your lordship will kindly take up the writ petition for a moment. First, page 37.
Yes.
Page 37 of the writ petition. This is the offer of appointment. And at condition number 5, in the second paragraph, it says appointment of Dr. Ramapada Bhattacharya shall be subject to the following terms and conditions. Serial number 5, you also will see. He shall be governed by the NERIS rules and the Government of India rules as applicable mutandis to the employees of NERIS. Then the order of appointment itself, which is at the next page, page 38. Your Lordship will kindly see the last paragraph. All other service conditions not mentioned herein will be governed by the central government rules. Therefore, my lord, all these documents, he was all along aware. That is why what he first does is, he is released, he takes his retirement benefits. It's not that we forced it upon him. He asks for it and we release it in June. And he approaches this honorable court in September. So therefore, his conduct gains significance in this case. These are the cases where the Honorable Supreme Court has said that before entertaining such writ petitions, your Lordship will look into the conduct of the petition, whether he has been fair to this Honorable Court or not, whether he has disclosed each and every relevant fact or not. And only thereafter, your Lordship, now, in fact, if I recall correctly, when my lord was sitting in the Itanagar bench on the issue of suppression and conduct, I had placed the judgment. I would like to place that once again. Over 2008. This is the famous KD Sharma. Till KD Sharma, your Lordships will recall, the Supreme Court used to say that the High Court should not entertain. But KD Sharma almost made it an obligation. That is the difference between the earlier judgments till KD Sharma and the law since KD Sharma. If your Lordship will kindly, I am relying on paragraphs 34 to 39.
Just give that citation.
Well, the citation is 2008, volume 12 SCC, 481.
Two 2008, 12 is 481.
My lord. Has my lord got it?
No.
It was from the-
Yes, it is a one.
Paragraph.
Paragraph 34 to 39.
Yes.
The jurisdiction of the Supreme Court under Article 32 of the and of the High Court under Article 226 of the Constitution is extraordinary, equitable, and discretionary. Prerogative writs mentioned therein are issued for doing substantial justice. It is therefore of utmost necessity that the petitioner approaching the writ court must come with clean hands, put forward all the facts before the court without concealing or suppressing anything, and seek an appropriate relief. If there is no candid disclosure of relevant and material facts, or the petitioner is guilty of misleading the court, his petition may be dismissed at the threshold without considering the merits of the claim. The underlying object has been succinctly stated by Stoughton LJ in the leading case of Rex versus Kensington, etc., in the following words. It has been for many years the rule of the court, and one which it is of the greatest importance to maintain, that when an applicant comes to the court to obtain relief on an ex parte statement, he should make a full and fair disclosure of all the material facts. It says facts, not law. He must not misstate the law if he can help it. The court is supposed to know the law, but it knows nothing about the facts. And the applicant must state fully and fairly the facts, and the penalty by which the court enforces that obligation is that if it finds out that the facts have not been fully and fairly stated to it, the court will set aside any action which it has taken on the face of the imperfect statement. A prerogative remedy is not a matter of course. While exercising extraordinary power, a writ court would certainly bear in mind the conduct of the party who invokes the jurisdiction of the court. If the applicant makes a false statement or suppresses material fact or attempts to mislead the court may dismiss the action on that ground alone and may refuse to enter into the merits of the case by stating, we will not listen to your application because of what you have done. The rule has been evolved in the larger public interest to deter unscrupulous litigants from abusing the process of the court by deceiving it. In Kensington, etc., where an ex parte application has been made to this court for a rule nicety or other process, if the court comes to the conclusion that the affidavit in support of the application was not candid and did not fairly state the facts, but stated them in such a way as to mislead the court as to the true facts, the court ought, for its own protection and to prevent an abuse of its process, to refuse to proceed any further with the examination of the merits. This is a power inherent in the court, but one which should only be used in cases which bring conviction to the mind of the court that it has been deceived. Before coming to this conclusion, a careful examination will be made of the facts as they are and as they have been stated in the applicant's affidavit, and everything will be heard that can be urged to influence the view of the court when it reads the affidavit and knows the true facts. But if the result of this examination and hearing is to leave no doubt that the court has been deceived, then it will refuse to hear anything further from the applicant in a proceeding which has only been set in motion by means of a misleading affidavit. The above principles have been accepted in our legal system also. As per settled law, the party who invokes the extraordinary jurisdiction of this court under Article 32 or of a high court under Article 226 of the Constitution is supposed to be truthful frank and open. He must disclose all material facts without any reservation, even if they are against him. He cannot be allowed to play hide and seek or to pick and choose the facts he likes to disclose and to suppress, keep back, or not to disclose, conceal other facts. The very basis of the writ jurisdiction rests in disclosure of true and complete correct facts. If material facts are suppressed or distorted, the very functioning of writ courts and exercise would become impossible. The petitioner must disclose all the facts having a bearing on the relief sought without any qualification. This is because the court knows law but not facts. Now, in this paragraph, my lord, what I was pointing out to your lordship, paragraph 39, where it has been made a little more strict, KD Sharma onwards. If the primary object as highlighted in Kensington is kept in mind, an applicant who does not come with candid facts and clean breast cannot hold a writ of the court with soiled hands. Suppression or concealment of material facts is not an advocacy. It is a jugglery, manipulation, maneuvering, or misrepresentation, which has no place in equitable and prerogative jurisdiction. If the applicant does not disclose all the material facts fairly and truly, but states them in a distorted manner and misleads the court has inherent power in order to protect itself and to prevent an abuse of its process to discharge the rule nicely and refuse to proceed further with the examination of the case on merits. This sentence, follows. If the court does not reject the petition on that ground, the court would be failing in its duty. In fact, such an applicant requires to be dealt with for contempt of court for abusing the process of the court. So in these last two sentences, the apex court has made the test even more strict, because you cannot abuse a judicial process to your advantage. Here is a registrar of an institution, centrally funded institution. He approaches this honorable court. What he does, he first takes all his retirement benefits. 2-3 months later, he files a writ petition. In that writ petition, he does not disclose, yes, these documents which I have pointed out to your lordship may not accept it while adjudicating. But what KD Sharma says is, even if whether it is in your favor or against you, you are duty bound to place it before the court in a fair manner. And not only does he not disclose these documents, he makes a further, he goes a step further. He points out to this honorable court a rule which is not even adopted, a rule which is in the draft stage, and takes an interim. So therefore, in my respectful submission, my lord, my first submission is, this is a writ petition where your lordship will come down very heavily, considering the nature of the post that he was holding. Your lordship will come down very heavily on him. Your lordship will refuse to enter into the merits of the case, dismiss the writ petition with exemplary cost. Now, my lord, this my second limb of the argument is.
But still that accusation is something which by the RTI reply, that has been admitted that those were being followed.
Well, to the extent possible, it is being followed, because there has to be something to guide. But so far as the retirement age is concerned, how can we bend it when we have adopted the CCS, CCA rules and the FRSR, and those rules are binding on us, and the ministry says that when we sought the advice of the ministry says that he will retire at the age of 60. It is not a, your lordship will kindly take note of a fact that your lordship is not examining the decision itself. While exercising our jurisdiction under 226, your lordship is looking at the decision-making process which led to the decision. It is essentially a judicial review of the decision-making process, not the decision itself. The onus will be entirely on the petitioner, especially when a writ petition is being adjudicated. The onus would be entirely on the writ petitioner to show that step A, step B, step C, step D, step E, which ultimately led to a decision, let's say step X, these A, B, C, D, E were not arbitrary, not illegal, and it is not a decision that a prudent person would have taken. A prudent person reasonably instructed in law would have taken. So here is a decision-making process. We did not take a call ourselves. Since he was raising this issue, we referred the matter to the ministry. And the ministry tells us, no, sorry. He will retire, you are bound by these rules, and he will retire at the age of 60. And based on that, we took the final decision to release him. So where, in my respectful submission, where is the arbitrariness in the decision-making process? That is my second limb of argument. My third limb of argument is, for a moment, your lordship will ignore whatever I have submitted. Assuming your lordship accepts the petitioner's argument in totality, if your lordship accepts his argument in totality, absolutely ignoring my submissions or the pleadings placed on record by way of an affidavit, what relief is available to him today?
The second part of the prayer, that is benefits till 62 would be entitled to him, Annexure 12C.
At best, it will be notional with financial benefits. But what is the principle? The principle is no work, no pay. Initially, he was allowed to work by this honorable court by way of an interim order. That interim order was vacated by this honorable. Of course, on an application made by us. So he has not, physically, he has not worked.
No, but it's a settled law that once he can demonstrate that he is not being able to work because of some steps.
Yes. But it has to be, for that, my lord, your lordship will have to hold that the decision-making process is illegal and arbitrary. Only when he is able to establish that the decision-making process has been so arbitrary that a prudent man reasonably instructed in law would not have taken. Even assuming, my lord, this in fact is my next limb of argument. My next limb of argument is exactly that one. He has placed some materials which give an indication that the retirement age could be 62. It is not a conclusive material placed on record, substantially established, conclusively established. There is a set of documents relied on by the petitioner. We have placed on record the relevant rules, the Board of Management decision taken way back in 1984-85, the ministry's advice. Even in spite of what we have placed on record, at best, it can be said that there are two views which are possible in this case. One is a view projected by the petitioner and one is a view projected by the authorities. Right from H.B. Gandhi onwards, Supreme Court has said that since it is an adjudication of the decision-making process, a judicial review of the decision-making process, if two views are possible, and one of those two views have been taken by the authorities, your lordships, while exercising jurisdiction under Article 226, will not interfere. This submission is made This submission has been made, my lord, as an alternative argument. In case your lordships do not accept my first three arguments, even then, it is at best a case of two views being possible. And the authorities have taken one view, one of those two views, and that too on the advice of the central government, which is the funding agency. So therefore, will your lordship, while exercising the extraordinary powers of judicial review under 226, now, my lord, my fifth and last final submission. In paragraph 5 of our affidavit in opposition, what we have stated is, I'll read it off. Broadly, what we have stated is, these are the rules and guidelines that we follow in arrest. And therefore, all employees are being retired at the age of 60. All these rules that I have placed before your lordship have been referred to in the paragraph, and your lordship will just take up the last sentence of paragraph 5.
Just tell me.
It reads like this, man. We have referred to all these CCS, CCA rules, etc., and the last sentence reads like this. Accordingly, all categories of employees at nearest are being superannuated on attaining the age of 60 years from time.
Yes.
It is for this reason that the petitioner has not been able to place even one instance that Mr. X or Mr. Y, who was holding the post of registrar earlier, or assistant registrar, or deputy registrar, has been retired at the age of 62. Because he knows that this is the uniformly applied and uniformly followed practice in Neris. And on this aspect, my lord, even if there is some gray area in the rules, guidelines, etc., on this issue, my lord, may I place two judgments for the Supreme Court. One is that famous Suresh Nathan case. This is the first time the apex court had the occasion to deal with a situation and accordingly answered it accordingly. There was a scope for two possible interpretations of a particular rule. May I, before reading out the judgment, may I just give the background of the case? There was a scope for two possible interpretations of a particular rule. And the department concerned was resorting to one particular interpretation uniformly, all true. The Supreme Court, in this kind of a situation, said that there are two interpretations possible, and the authorities are resorting consistently to one of those two interpretations. So what has added force to that interpretation is the uniform practice And that will not be upset by the courts. Relevant paragraphs are, my lord, paragraphs 4 and 5. So, in a sense, the ratio laid down in this case is, in fact, I won't trouble your lordship with the judgment. I will just, I'm giving the paragraphs, relevant paragraphs. I'll just broadly outline.
Citation.
Citation is 1992. Supplementary Volume 1 SCC. 584. Paragraphs, relevant paragraphs are paragraphs 4 and 5. And following this, there is another one, Shailendra Dania.
How do you spell it?
SHAILENDRA. And Dania is D for Delhi. DANIA. Citation is 2007. Volume 5 SCC 535. And the relevant paragraph is paragraph 36. Essentially, my lord, the ratio laid down in these two cases is that if there are two possible interpretations of even of a rule, and one of those interpretations is consistently followed. In fact, the language used by the apex court is uniform practice. If there is a uniform practice which favors one particular interpretation, that will hold the field. So therefore, my lord, in my respectful submission, looked at from any angle, this is a writ petition which deserves to be dismissed. And for having, as per the language used by the apex court, for having played hide and seek, for having not disclosed, particularly considering the fact that you yourself were a registrar for a long period with access to all these materials. So your duty was to place all these materials on record in the writ petition itself, and then tell the court that here is a situation where perhaps there are two possible views. One set of documents show that the age is 62, one set of documents show that the age is 60. So your lordships will decide, adjudicate whether it should be 60 or 62. But to do that, now if we take away the affidavit filed by Nerist, your lordship would have been adjudicating this writ petition on the ex parte facts, which are not complete. So therefore, my lord, this is once again at the cost of repetition. This is a case where your lordship would perhaps apply the law laid down in KD Sharma and not even go into the merits of it.
Yes, Mr. Khalid.
I'm deeply obliged.
Let me judge. The petitioner, first I must clarify, he was the first register appointed in Nerist. There is no register before him. Huh?
No register superannuated.
Huh? No register was superannuated before him, lordship. It's the first register in that way. Now, the petitioner has filed this writ petition based on certain documents, and he has not stripped out of those documents, lordship. All these annexes are genuine documents. The question of misleading the court, every statement is supported by certain documents, the annexes. So the question of misleading the court or suppressing fact, all these things do not arise at all. Thirdly, lordship, recruitment rules 14. I stated the recruitment rules 14 says age of superannuation 62 years. And the Nerist itself admitted in many times in the earlier replies that there have been rules prepared by them since 1997 till 2014. None of these rules have been so far approved by the ministry, but we have been following those rules for appointment and making service conditions the employees. So where is the wrong statement that I have made? Rule 14 says 6 years. Yes, they themselves have been doing everything as per the guidelines of the agencies and by the rules. So that's nothing wrong. Rule says clearly 62 years. The ministry later says, if you do not have rules, AICT rules, go to NIT. NIT itself says that our register retires at the age of 60. So suddenly bringing about age of 60 would not help the institutes. Then the fundamental rules also say there are certain procedures, the retirement. If the employee is informed in advance that it's 3 months, 6 months that you are going to retire, prepare your papers. I'm informed. They also think when I joined on 1st of May, after I availed some services and some are leaves, I was never said that they have retired. They should have done it. And that day also they have received the intimation from the ministry at 3 p.m. I was allowed to work. I worked till 6:30. I've asked to sign some checks. I've signed it. Then says you have retired and this is your release order. And unheard of practice in any government department. Never done in that way. Now, Lordship, they said I have already claimed my retirement benefits. No, Lordship, these are not retirement benefits. I'm entitled to certain THDs and certain other amounts that I have claimed. This is not retirement. These are my amounts lying in the institute. After retirement, I need suddenly retirement. I have not been able to plan for my future. So I said, these are the amounts. Since you're not my representative, you're rejected by them. Since you reject my representative, give me the payments. These are my money lying with you. I need the money for settlement. Sudden plan, Lordship. And 84, 85 bombs, Lordship, 84. Things have changed totally. That time, it was just established and that these rules should be followed. But thereafter, it has been taken over by UGC. It is made a deemed to be universities. UGC, they 71st meeting of the bomb and 85 meeting of the bomb. They have changed it. Whatever changes, modifications made by the UGC, we should adopt that. So that what happened in 84, 85, totally irrelevant of what's happening today. So therefore, Lordship, I submit that. And that affidavit in the voice reply also. I've annexed certain documents. These are all genuine documents. I have not made any separation of facts. Every statement is based on certain documents I've annexed to it. Lots will see that their conduct, how they have retired me. So that's my submission, Lordship. This is something is fishy on the part, Lordship. Suddenly retiring me a day after continuing. There's a clause for interpretation of clause, Lordship, in the memorandum article, Lordship. Clause 27, I will place the memorandum, Lordship. In the event of conflict of opinion with regard to interpretation of memorandum association or the rules and bylaws, the opinion of the agency shall be final. That's what agency says, Lordship. And when I wanted
You are referring to what?
Lordship,
You are referring to what document?
this is memorandum of, I'll place it before Lordship. Memorandum of Association, Lordship, of North Deemed University of Nedis, Lordship. Clause 27. That's my submission, Lordship. On that. The question whether it has become influxes, there is a decision what you will kindly perish, what you convenient.
On what point?
This is that it was contended that the repetition is becoming infructuous. It is judgment deals with that mainly because order is implemented, it will not, that the question of legality of a order is challenged, that will remain to be discussed. What's made? Para 6 is relevant. One line. Thank you. There are 6 lordship, one line. There
Just stop.
That's
No, I don't think this applies.
lordship.
I don't think that this applies. This,
Para 6 says, I just read out a line. Para 6 expression infructuous means ineffective, unproductive, and untruthful. It is derived from the Latin word census. By implementing an order, the challenge to the validity of the order is not wiped off and is not rendered explicit. The order is challenged, by the mistake, order has been implemented.
no, Mr. Kakote, this can't be accepted. You see, for a different reason. Now he's of 65 years of age.
Lordship.
That is the reason why Mr. Chaudhary is saying that it is otherwise infructuous.
Sure.
Number one. Second is that in this case, what had happened was that the person was removed from service. He was restored by virtue of order passed by the tribunal.
Lordship.
Correctness of the orders of the tribunal was challenged before the High Court.
Lordship.
And High Court says that once the tribunal's order has been implemented, it becomes infructuous.
Lordship.
But that can't be, that the order of the tribunal can be challenged. That's why the Supreme Court says that the challenge is maintainable and therefore it is not infructuous. Here in this case, the interpretation is because of that fact. It does not say that even if he's he's 65, the matter would not have been made infructuous. That interpretation can't be made.
No, that my challenge to that order, legally to the order, that challenge remains.
No, you see, the second part is that once you accept the retirement benefits,
No, retirement is, they are all.
this
clear,
was no, you look at the receivables. I think it is retirement benefits. Once you accept that, then perhaps you can't challenge because the receivables were not under protest.
No, that was.
That was
I
never
have
kept alive.
representation, my representation pending. Meanwhile, I said, whatever amount is due, that these are the amounts I'm otherwise also
No,
entitled.
just
This is not retirement benefit.
just a query. It may not be appropriate, but still it's a query. You see, there is a petition for amendment of this writ petition.
Lordship.
There is an application for amendment of this writ petition.
Lordship.
I allow this amendment at a cost of say rupees 5,000. Mr. Chaudhary accepts that 5,000.
Lordship.
Then perhaps he can't challenge it, having accepted it. But if he does not accept that amount, auditor's cost, Mr. Chaudhary can still appeal against the order of amendment.
That is two different, Your Lordship, that these are
But
my
once you make a prayer that pay me my retirement benefits and it is paid,
No,
then your claim, how can it be alive? You have accepted that that part.
I'll just get a claim. What did you apply for? Pending checks. Pending checks. He applied for the pending checks. Checks are due to him, not for retirement benefit, Lordship. Retirement which are still due. Yes, still due.
Your lordship will just have a look at that. The heads under which payments were made. Gratuity is paid. Leave encashment is paid. What else does a man get on retirement? Leave encashment is not during pendency of the during the incumbency of a servant, government servant.
These are my service entitlements, Lordship. These are the amounts I'm
The
entitled.
heads are, my lord, employees
No,
contributed.
I asked for, but the fact that the order was, I challenged the order, Lordship will examine my challenge whether order is valid order or not, based on documents.
Okay, I'll pass orders today. It's been released because I have to save some time today.
My lord.
Um, Okay, because I have 10 matters more in the board. If time permits, I'll give the dictation in the left part of the day. Otherwise, it will be rollover and orders.
Lordship, in this petition, there are two prayers, Lordship. One is for bringing the petitioners under the old pension rules, and another is for the payment of arrear salary, Lordship, for the services rendered by her. Lordship has referred to an order in the morning 31-3 passed by Justice D. Borua. Lordship, the order is a bit long, Lordship. I have to distinguish it. Lordship needs some time. Lordship may fix any day.
Lordship, this one thing, the order I have got it, Lordship, regarding excess teachers, they have specifically made distinctions over here. And regarding excess, my lord, they have all in paragraph page 393 to page 400 is the relevant part, where they have given that they don't have a right, Lordship. I'm just pointing it out.
No, it's okay, but if it's a long judgment, she needs
She
some
has
time
some
to.
time, I understand.
But I'll fix it after view.
Lordship, may fix the date. I'll come prepared, Lordship.
Both sides are duly represented. It is submitted that a similar matter has been decided recently. And therefore, the learned counsel for the petitioner seeks some time to go through it and address the court. So matter stands adjourned today. List on after vacation, due vacation.
28/4. Lordship. Much obliged, Lordship.
Deeply well.
13.
May please, your lordship. This is the second bail application, lordship. As on today, 88 days behind the bar, your lordship.
Okay. Yes.
My lord, we have received the case diary, lordship. Lordship earlier, lordship rejected on the basis of the, my lord, the statement of the victim girl, lordship. There are materials in that, my lord. In the case diary.
Still, if the case diary is here, that means the charge sheet has not been submitted.
Not submitted, lordship, and today I have calculated around 89 days, lordship.
89.
The strength of but Mr.
Yes, Islam, your lordship.
S. Islam, the counsel for the petitioner, as well as Mr. Ajay Barwal and ABP for the state.
And only my objection may be recorded.
You see, that is why initially I did not ask for the case diary. I made it very clear. Updated status of investigation and scanned copy of the medical report of the victim girl. Only two things. Medical report, I think, don't think anything.
Medical report is not available, lordship, as per the last note of the investigating officer.
The petitioner was arrested on 5/1/2023 in connection with so and so, has paid for regular bail under 439 CRPC. The learned APP has produced the case diary and has opposed the prayer for bail on the ground that there are existing materials against, there are materials implicating the petitioner of the offense of sexually assaulting a minor girl aged 10 years. So it is also submitted that the earlier application for bail was rejected by order dated 21/2/2023 in BA 260 of 2023, and no new grounds has been made out
Lordship, new ground.
in this case.
Added your lordship. New ground is added your lordship.
Okay.
That's for right.
Next paragraph. On of the case diary. It appears that the victim girl is aged 10 years. And in a statement made before the Child Welfare Committee, as well as statement under section 161 and 164 CRPC, our petitioner has implicated the petitioner, the victim has implicated the petitioner of subjecting her to penetrative sexual assault. Be that as it may, it is noted that the petitioner spent 89 days in custody and till date, charge sheet has not been submitted. So accordingly, the court is inclined to release the petitioner and so on bail. One is furnishing a bail bond of rupees 1 lakh with 2 surety or like amount to the satisfaction of the
Special judge.
special judge, Kamrup Metro Guwahati. So this bail bail is granted with the following conditions. Next one. In the event the petitioner makes any attempt to meet the victim girl or anyone else in our family, it would be open to the IO to move the judicial court and apply for cancellation of bail. Petitioner should appear before the IO once every 15 days till his personal appearance distributed or charge sheet is submitted, whichever is earlier. Case diary is written. At least in this.
15 bail hearing.
May I please your lordships?
Yes.
Well, pursuant to your lordship's order, my lord, I had appeared before the IO, my lord. And I had complied with the my lord, directions given by your lordships, my lord. My lord, there is a note of the investigating officer, lordship. He has appeared before the IO statement recorded, lordship. Lordship may kindly peruse the last note of the investigating.
Okay, I'll not say anything. I'll just.
Well,
Trying to recollect, there was an old movie, what, Blinken. I just forgot the name.
what was the movie about, my lord?
There's a, if I remember it correctly, long back. There the man uses a woman for distraction and the crimes are committed. Heard Mr. G. Chaudhary and counsel for the petitioner, as well as Mr. R.J. Barwal and APP for the state. Next, for the petitioner was apprehending arrest in connection with Hathigam PS Krishna 438. Learned APP has produced the case diary. And has submitted the pursuant to interim bail granted by order dated 23/2023. The petitioner has appeared before the IO and his statement has been recorded. In view of the matters which are contained in the case diary, and the court is to consider opinion that custody interrogation of the petitioner may not be necessary. According to the interim bail granted by order dated 23/2023 is met absolute on the same terms. Next, the petitioner shall appear before the IO once a month till his personal appearance is dispensed with or charge sheet is submitted, whichever is available.
I am deeply obliged. Much obliged.
For order 16.
Well, this matter, my lord, I'm appearing for respondent number 1. And all the respondents are not with the department right now. All are referred. So possibly the new incoming is required to apprise the latest status of the case.
Now, a present call for the petitioner. Mr. S.P. Bhattacharjee and counsel for the respondent number 1. I should submitted that the said respondent has superannuated long back. And what about 2 and 3? They have also.
Nobody is there, my lord, right now. All have retired, my lord.
Is also submitted that as per information received by him, the petitioner number, the respondent numbers 2 and 3 have also superannuated.
None.
So it is noted that although although this contempt petition, the personal appearance of the respondents have not been dispensed with. But no affidavit in opposition is filed by any of the respondents. So what to do? I'll issue a warrant of arrest to all the respondents.
My lord, what I feel, my lord, because the party is also not there. But the only thing, the proper intimation has to be there with the present incumbents. So that part
So that I don't know. Even
I'll get that.
The contempt, whether you have committed, there also you're not respondents. So I issue order of.
More importantly, my lord, the petitioner should have included the new.
No, even if they don't implement, you have not filed your affidavit.
My lord.
So I'm issuing a warrant of arrest.
My lord, my part of difficulties is that in the year 2020, my lord, when I was formally not apprised about the department, my lord, to appear before this court, my lord. Only thing is that on the honorable court's note, my lord, I appeared because at that particular time also, my lord, possibly the party didn't appear to issue.
No,
so that's why I think
contempt is between the court and the contempt.
Absolutely, my lord. Absolutely.
But if you.
One thing could be done, my lord, but fix it on the next state, my lord. I'll take just latest updates with regard to this matter.
Because it is not filed, then I'll have to issue a warrant of arrest. The
if your lordship pleases to fix the matter on the next week, my lord, I'll take some.
Okay, next, taking note of the fact that this contempt petition is pending since 2016 and no affidavit in opposition is filed. The court was inclined to issue an order for to pass an order for issuance of warrant of arrest for against the petitioners, respondents. And at this stage, Mr. S.P. Bhattacharjee, Leonard, counsel has submitted that he is not the counsel engaged by the respondents, but at a particular point of time, he was the standing counsel for secondary education department and at the instance of the court, he had appeared. So he also submits that You're not the council now.
No,
You submitted-
not even the standing council. I resigned in the year 2020. Now.
Okay, you submitted that he is also not the standing council for the secondary education department at present. I suppose that you try to obtain updated instructions and produce the same before the court. First off, matter stands adjourned today. List on. I'm making it 3rd of May.
Month.
17,
May please, Your Lordship, matter relating to non-compliance order dated 21/3/2016, Lordship. Page number 18. on adjournment.
Well, here also I was appearing for the respondent number 1, Madam Pritam Saikia, but he's also not there, Madam.
Respondent number 1, has he filed an affidavit? No.
No.
Then you can't exonerate him.
There was an order, my lord, 22nd/11/2019.
What does it say?
My lord,
Yes, one number 1 was directed to take instruction, Lordship.
here, my lord, the involvement of BPC is also there. Here, my lord, so I recall, my lord. Last year, my lord, there was an update from the department, my lord, that the department has sought for some proposal from the concerned department. That was, but I'm not very much sure, man. That was.
My lord, BTC is there, my lord, but there is one.
No. Report. Page number is 12. So, Professor, again, you are defending this Pritam Saikia.
My lord.
No, he is not filing as affidavit. We have to issue a warrant of arrest. In one case, if I don't issue a warrant of arrest, these people will not be, we can't do anything about it.
He is also not there, my lord.
So he may not be there, but he'll have to appear.
Otherwise, my lord, there may be, my lord, my part of fault also, my lord. I'm considering it, my lord. Because during that particular period, my lord, when I was a standing counsel, 3 years
it was under huge sort of corona and all this. So we couldn't only the email. I'm having the emails and also the email. But only
It's
thing is,
okay.
my lord, PTC has come up with the final decision, my lord, that they are not entitled to this. Because if your lordship see the judgment, where it was there, my lord, in a specific recital is there, my lord.
Who was the respondent number 2 in that judgment?
Respondent number 2.
Show me that.
Commissioner and Secretary, Lordship.
Hmm?
Commissioner and Secretary, Elementary Department.
Number 2.
Lordship.
Number 2. Yes, lordship.
So this decision was to be taken by him. As per the judgment, decision was to be taken by him. BTC could not have taken the decision.
Well, if your lordship sees the, well, there was a report called for. I think your lordship is absolutely. First. Final decision. Yeah, because order to school.
Yes. 30 September report is not there.
September report.
Now, if you don't imprint the new incumbents, nothing will happen in your case.
It can be allowed to receive.
Because otherwise it will not implement. It will not proceed. Yes.
The doctor.
The doctor and the petitioner. Petitioners, please for some time to file an application for including the present incumbents. The petitioners may do so after serving the present incumbents notice requiring them to comply with the order of this court dated 21/3/2016 passed in WBC 1953 of 2016. Mr. Your name?
Again, sir.
R.K. Musari, and counsel for the BTC, has produced a set of income documents. The court does not find any of the documents produced to be relevant because of the fact that in communication bearing number capital ELC oblique COP within bracket C bracket close 623 oblique 2016 oblique 1620 oblique 131 dated 10/9/2021. It is mentioned therein that the Director of Education BTC was to submit a comprehensive report within 30/9/2021. So this said which was observed after examining the expert committee report dated 1/9/2021. For reasons best known to the BTC authorities, the subsequent comprehensive report to be submitted within 30 September 2021 is not produced. A stand is taken in the affidavit in opposition filed by the respondent number 3 in affidavit in opposition filed on 11/3/2019. which is also reflected in the communication number, capital ELC, public COPC 623, public 2016, public 1620, public 135, dated 38/2022. Wherein reference is made to the decision in the case of Haren Chandra Das, HAREN Chandra Das, versus State of Tripura, 2009, within bracket 1, bracket 2 GLT, (1094). Harendra says HAREN DRA, Chandranath versus State of Tripura. Reported in 2009, 1 GLT 1094. Is appears to be an incorrect understanding of the respondent authorities as the state decision stood modified by order dated by division bench decision of this court in Harendra Chandra Nath versus State of Tripura, within bracket 2013, within bracket 2 GLT 1094, wherein the division bench of this court had held the claim for salary and allowance does not become stale by limitation. However, the payment of arrears will have to be restricted to a period of 3 years prior to the date of the original application. In this case, the court is not examining the original claim of the petitioner, but is a contempt petition where willful and deliberate disobedience of order of this court is subject matter of examination. Therefore, be that as it may, it appears that the personal appearance of the respondents has not been dispensed with, and therefore, if by the next date of listing, no further instructions of compliance is put forth, the respondents, namely Shri Pritam Saikia, former Commissioner Secretary, Government of Assam, Elementary Education Department, Mr. Robinson Musahari, ROBIN SON Musahari, the then Secretary BTC, and Sri Ravi Shankar Borgiari, the then Director Education BTC, shall be personally present before the court.
My lord, the director of petition already retired.
Let them retire. We are not bothered with that. Retired person has to come. He'll have to show that during his tenure, what did he do? And be prepared to take bail. The donuts standing, the council for respondent numbers 1 and 1, as well as 2 and 3 shall communicate the order to the respective respondents.
May I just put it a different title? But it's all that your lordship has passed an order directing the APL. But I'll communicate it. My position will be in a different one because I'm not more standing counsel of the department as of now.
No, but you appeared through Vakalatma. We can't avoid
there.
you.
But here also I'll have to check right now. Yes, I'm there.
Vakalatma is there in
But
Vakalatma.
I'm there. I'm there with the Pritam Sekar. I'll just communicate with him.
That's why I put in two things. Number one, despite your superannuation, number one, requirement to demonstrate that what you have done has to be there. The requirement is of the order is that you will have to, it is for the commissioner secretary to take a decision. So either he takes a decision or he washes off his hand. But he can't wash off his hand because the order of the court has not been modified. The requirement is of respondent to take a decision.
I've seen that. The matter was placed before the expert committee after receiving the relevant documents from the director BTC.
And the expert committee again says that listed it should be examined by another expert committee.
Thereafter, my lord, the commissioner secretary has to pass on order.
So what they know what is to be done,
my lord.
But they are just passing on the buck. Correct.
I should restrict myself.
No. It is because of that I read both the affidavit in opposition.
I understand.
I tried to understand what the matter is about. That thereafter I commented on the documents produced by Mr. Masari.
Well, one insistent, I'm saying the lordship would consider certainly. The present incumbent and the standing council may have to be directed by this court, my lord, to get the latest status. Otherwise,
no, in contempt I can't give the direction. That is why I have requested her to
implement.
She has taken the cue and she has agreed to implement the new incumbents. In contempt, you know my limitations.
That would certainly take some time, my lord. Otherwise, a simple notice would, because it's a government matter, my lord, they should take up. The moment notice come to the concerned officer present, my lord, they should act.
No, because the fact is that since we are becoming complacent, not issuing warrant of arrest, this is what is happening. 2016, nobody is bothering to comply with the orders. They merely appoint a high power committee, and in the contempt now they are taking a stand that that it is barred by same is barred by limitation. That's why we have to make them understand. That's why this order.
My lord, apart from all this, my lord, again I'm making one request to lordship. That part, my lord, I will certainly communicate that they should present before this honorable court.
You file an application for exemption. You can always do that because then they will be under pressure. And the message must go that the court is serious on contempt matters.
Even my part, when I was a standing counsel of the department, I used to send a hard copy of the notice at the same time one email.
No, you see,
but now they are working. Now the present set of officers are there quite. So from my experiences,
no, I'm not saying they are not working. Even the Advocate General came and made a statement that the department is working, but still I find that when it comes to contempt, they don't bother.
My difficulties is that, my lord, at this stage, not being the same counsel of the department, my lord, it would be difficult to call them and ask for the latest status. Even I'm not supposed to do that because I'm not the.
No, correct. You're
that's
You're
the issue.
Right.
That's the issue.
But this highly pressed of the astral officers, they'll be in a position to do it. Once this order goes, he'll do it.
So Pritam Sekar is presently the special secretary home.
Okay, so he'll do it. There. Don't worry.
Well, may I have that order of this?
Okay, the council are permitted to send the downloaded copy of this order to the respective authorities.
Deeply order still option.
If he's home, he knows more means than one to get his work done.
Otherwise, my lord, off the record, he's a fantastic fellow. That's what I'm saying.
But then he would know how to get the work done. He'll get work done.
So to get.
Huh? 7. Oh, 7. Hmm? 3-5. 3-5.
19.
No, please, Your Lordship. In this matter, this senior counsel is on lax, madam. Matter may be taken up after purification, madam.
No, just right, 2018 matter. I'm just not adjourning like that. Let me understand what the matter is about.
19.
Lordship, in this matter, the compliance is come, my lord. I've sent the,
Show me that.
I've given the copy.
Okay.
I do, compliance.
Just tell me what is that?
Lordship,
Uh,
there's a letter with the reference to the subject cited above. I'm directed to inform that in compliance of the Honorable Court's final order dated 2/3/2010, passed in WPC number 1048 of 2004, the Education Department placed the matter of regularization of irregular teachers before the Cabinet in its meeting held on 26/2/2011. Thereafter, the Education Department proposed the constitution of screening committees to examine the cases of these teachers with a view to examining the selection procedure, the nature of appointment, status of posts, working status, status of salaries, academic qualifications, etc. The Director, Elementary Education, Assam, invited applications from these illegally appointed teachers during 91 to 2001 throughout the state by an advertisement dated
Just a moment. Just a moment. I've not been able to follow you.
My lord,
Because of the fact that you are referring to a writ petition of 2004.
my lord.
This 2004 writ petition, what is it about? I don't know. Because here the here the reference order is 17 to 2017 WPC
My lord.
3286 of 2014.
My lord. My lord, if your lordship sees the subject and the cases referred, my lord, number WPC 4054/2006, in compliance of this manner.
No, again, doesn't match.
Contempt cases, my lord, 124/18. Gopal
124
Chandra,
is okay.
my lord, and
but
in link number is WPC 4054/2006.
Something else. It's not this case. Acha, this is a different matter. Okay. Yes.
Connected, my lord.
Connected writ petition. Okay.
Then, my lord, a committee was formed, my lord, by the government and the Elementary Education Department to verify all the these materials. And accordingly, my lord, this committee prepared 3 lists, my lord, based on the screening committee's report.
Yes.
List 1, my lord, teachers who have received salaries up to 2007 and onwards and having BT, DLED are included in list 1. And second list, my lord, containing teachers who have received salaries up to 2007 and onwards and not having joined junior basic training and /DLED. And list number 3, my lord, includes who have neither received salaries nor have prescribed training. Subsequently, after a series of discussions, it was decided to resolve the issue of irregular appointment by way of preparation of a cabinet memorandum for placing it before the cabinet. Finally, in the cabinet memorandum. Number A, my lord, approval was sought for accommodating those teachers who have received salary up to 2007 and have successfully completed the JBT, that is junior basic training, DLED course by creating personal supernumerary posts with prospective effect from the date of approval of the cabinet.
No, Mr. Fogan, it will still not take, I'll not be able to follow. You see, you have the order contempt, the order in contempt with you, page 17. Sorry, page 16. But this is the exercise you can't do now. Look at the order, you will understand. This is an exercise you can't do now for the petitioners. No, you see, para 17, please read that, page 16.
Yes. Page 16. The petitioner appointed in the year 1989, they have rendered service for more than 28 years now. As a matter of fact, they were paid salary up to July 2007, that is for a period of 18 years. Continuance in service by the petitioners is not disputed. As per the admitted stand of the respondents, no termination order has been issued to the petitioners. In such circumstances, withholding of salary of the petitioners would not be justified. Consequently, impugn order dated 27/3/14 is set aside and quashed. Respondents are directed to release the arrears salary of the petitioners from August 2007 within a period of 4 months from the date of receipt of the certificate copy.
So that order was quashed. So therefore, for further inquiry is not within the scope of this judgment.
I don't may fix it, but I'll get my instructions then. What I got.
May I, madam? Madam, these are all are illegally appointed teachers, madam.
No, I can't hear it.
Yes, madam. And my lord, as per the screening committee, some of them are appointed.
Miss
Already 11 teachers have
No,
been
Miss Pukam,
appointed, my lord,
Miss-
accommodated as a tutor, my lord.
Ms. Pukam, please try to understand
My lord.
what you are addressing appears to be good,
Hmm.
but not sound in light of the judgment of this court. So therefore, whatever this order is, there's an old movie,
My-
Good, Bad and Ugly.
Clint Eastwood.
Yes. So I'm a big fan of that movie, whatever that is. Still, till the date this order is not modified, you can't do anything about it. We'll have to just comply with it.
My lord.
So your screening committee or your other, whatever endeavor you are making, unless you can show it is within the scope of this judgment, the contempt is still made out.
My lord. My lord, my humble prayer is that, my lord, all the similarly situated cases, all the similar matters, fix on 28/4, my lord. So kindly matter may be taken at 28/4,
No, contempt, those are matters for consideration
my lord.
of a writ petition.
Already
This is a contempt
11,
petition.
already 11 teachers accommodated, my lord, by the
But this is a
department,
contempt
my lord,
petition.
as a tutor, my lord.
This is a contempt petition. Why should we wait till then?
Yes, my lord, as per the. My lord,
This is a contempt petition. You
Yes.
have to show compliance.
area salaries may be born and more likely. Okay, area salaries. So, my lord, matter may be taken at 28/4, my lord.
No. At best, because of our ability now, we'll take it up on in the next, just after the opening, after views. But that point is not taken. The same order is in last case. We'll ask for personal appearance of the respondents.
Kindly, my lord, kindly matter may be taken at 20.
I'll take it up, but I'll call for the personal appearance. These things must be
Hello,
sorted out.
All the teachers are illegally appointed, my lord.
No, I
So-
understand, but nobody prevented you from filing an appeal.
Kindly,
Nobody prevented the department from filing an appeal. Once this order has been set aside, you are directed to make payment. Now you can't make an inquiry whether they are legal or illegal.
yes, my lord.
Even if they are illegal,
Can-
you have to pay them. Which I'm not sitting in appeal over their judgment. I want to just see that whether it is complied with or not. But Mr.
D. Bhuyavan.
Non-counsel for the petitioner. So,
My lord, for the last time, I have to talk with the department.
you do it, but
Thank
will you file an application for exemption for personal
Right.
appearance? But we must be strict now. 2018 matters if it remains like this. Mr. A. Fukan, as well as Ms. Ann Fukan, and then standing counsel for the Elementary Education Department, have separately submitted that the petitioners form a group of illegal appointees who had received salaries up to 2007. So it is also submitted that in the meanwhile, the government in the elementary education department, in compliance of order dated 2/3/2010, passed in WPC 1048/2004, had placed the matter of regularization of illegal or irregular teachers before the cabinet in its meeting held on 26/2/2011. And thereafter, the matters were placed before the 5 screening committees headed by the respective divisional commissioners. And principal secretaries of the sectional areas and BTC to examine those applications. And the screening committee, and based on the screening committee reports, 3 lists were prepared, being list 1, relating to the teachers who have received salaries up to 2007 and onwards, and having capital JBT oblique D full stop L full stop ed. The list number 2 consists of teachers who have received salaries up to 2007 and onwards, and not having capital JBT oblique DL ed. And list number 3 consists of those who have neither received salaries nor have the prescribed training, i.e. JBT oblique DL ed. So accordingly, it is submitted that in connection with the present contempt case, the authorities have found that the petitioner numbers 1, 2 and 4 to 11. So 4 to 12 have already been accommodated as tutor, and insofar as the petitioner number 3 and 13 to 18, no record is found in the screening committee list. Next paragraph. The submission of the Learned Standing Council for the respondents appears to be attractive. But on a perusal of the order dated 17 to 2017, passed in WPC 3286 of 2014, the operative part of the order is as follows. Page 16, para 17. So therefore, the court has to restrict itself to see whether the order of the court has been complied with.
Yeah.
And the photos of the considered prima facie considered opinion that inquiry, if any, would not come into the way of compliance of the above referred order. Next paragraph. It is observed that the personal appearance of the respondent. Respondents has not been dispensed with. And therefore, the court is inclined to direct the respondent authorities. But the respondent is not authorities, respondents. Numbers 1 to 4. Namely, Sri Pritam Saikia, the then Commissioner and Secretary to the Government of Assam, Elementary Education Department. And Mr. Sanjeev Kumar, just give the names at page 5 of the contempt. Sanjeev Kumar Bhaiya so and so, Dr. so and so, and number 4 so and so. Person present before this court. On 26/4/2023. Next, by the learned standing counsel for the respondent shall transmit a copy of this order.
Sanjeev Kumar, we are in a very critical condition, my lord, now.
No, it's okay. You file an application for his exemption.
Yeah.
Um,
Well, can I pray for a last chance, my lord?
We'll give it to you, but you file an application for those what do you call exemption. Otherwise, you see, we can't control these officers
My lord.
in contempt. These are pending since when? 2018, 5
Can we
years.
For last time, my lord,
No, it's okay.
my lord,
You file an application
my lord.
for exemption. So to send a download copy of the order to the respondents. Next, at this stage, the learned Mimi Sain Fukan, learned counsel for respondent number 2. Submits that she is informed that he is in a critical condition. Mr. Will, if that is for an application for exemption from personal appearance be filed prior to the next date of listing. List on so and so.
Deeply organized.
The instructions for this are written on record in record. List on so.
Highly obliged, Your Lordship.
21.
In this case, your lordship may see the last order of the court, my lord, is a 2/3/2021. After that, some instructions were called for from the respondents.
Yes.
Yes, your lordship. Lordship, with regard to whether the communication was made or not, your lordship, I received on I think a year back only, somewhat, but communications were sent on 14th June 2019 to the principal Hamidabad College, Satsia, president of the governing body, Hamidabad College, the petitioner, and Abdul Samad petitioner. Abdul Samad, that is also the petitioner, your lordship. So, your lordship, what
Yes.
Lordship, your lordship permits me, your lordship. May I just clear the fact a bit? Your lordship, perhaps the order was that the direction to the discrete scrutiny committee to peruse the records and come to a finding, your lordship. But the fact is that they filed a writ petition on 2014, order was on 2017, your lordship. But now the communication that has been sent to the district inspector of school Dhubri, your lordship, this is vital. Finally, your lordship, may I peruse a bit by the principal of that college, your lordship.
He has not produced the relevant books.
No, your lordship, the present incumbent has lodged an criminal complaint case against in the court below against that predecessor principal, your lordship, because there is clear conception with regard. So if that the same would have been brought in the writ petition, then definitely now this situation would not have arisen. But from my limited understanding.
You see, nothing will happen.
Otherwise, now the present, what they in the affidavit also I had mentioned, your lordship, that presently the records that are there in the custody of the college school Ahmedabad college, yes. In the record present that are available, it doesn't speak so. And that has been stated in the affidavit also. Records dating back from that 1998 to 2009 are of essence, which are with regard to which the complaint case has been there, that it has been mistraced by the then principal.
No, you're not getting it. This case is not there in the record.
But that has been made in several communication and has been filed in the affidavit. So then I have to personally clarify with regard to that. It will be 20.
You know, this document, you have a copy of this document you have given me?
No, I have not
No.
written.
Yes. Yes. It just takes
Your
about,
lordship, lordship may
No,
just
no,
have
I'm showing
mention
you
of the
something.
status report that they had furnished.
I'm showing you something,
Okay.
just not for nothing.
Okay.
You see, in the document you have given me, the page I have opened up, just look at the top. You will find that GR number.
Hmm.
No, in your copy, in your document,
Yes, your lordship.
in the top, you will find handwritten GR number.
Yes, yes, your
Correct.
lordship. Yes.
Now match this with the copy I'm giving it to you. The accused have been acquitted,
Yes. Your lordship.
2015, and now you are still getting that status report. I'm asking for a personal appearance. You suspend that man in the meanwhile. If that is what is, you see this order.
Yes, your
Accused is
lordship.
present. Accused is acquitted. And what is the date of the order? 2015.
2015.
So you are in 2013, 23, you are still,
Yes,
you are
yes,
still
yes.
bringing the status
Yes.
report.
This
same
concern,
Same story.
concern principal, the principal, the main.
No, I
Yes,
understand.
yes,
See,
yes, your lordship. Because he should not have, the status of that case should have been known to him. That principal, your lordship. He was the one to furnish to the inspector of school.
no, but your officer
Yes,
is
yes.
believing it him.
Yes,
Why we are computerizing everything?
Hmm.
Everybody can have an access to from everywhere,
yes.
but you're not getting an access.
Hmm.
Not tap to. So I'll call for his personal appearance. In the meantime, your officer can suspend him.
Lordship, if we go through plain reading, because the complaint was lodged with regard to the loss of empty, but order doesn't say about all of those.
No, you see,
Yes, your lordship.
you see, with some experience in trial court,
Yes,
I
your-
can tell you what is happening.
yes, your lordship.
This man was asked to produce the records. He conveniently, you see, this order of producing records
Yes, your lordship.
was on 6/6/2017 in WPC 5584 of 2014. Correct.
Yes, sir.
He now shows that 2010, the documents are already lost.
Yes,
So if a official record is lost, why will he go to the CGM court and file a complaint case? He should have lodged an FIR.
yes.
He doesn't file an FIR. He goes to the court, CGM court, and files a complaint case. So that is why doubt was created, and I had to see this.
Hmm.
Why would somebody file a complaint case in his official capacity? Why would somebody waste his time and go to court, give evidence, prove the loss? In a complaint case, can you prove loss? You can't do it.
Yes.
You got to lodge an FIR.
But lordship, the district scrutiny committee actually needs those documents to come to a finding. So that.
No, but then now
Yes.
you see, if the complaint case is not there,
Yes, yes, yes,
how will your officer do it? He is relying on this headmaster.
yes, yes.
And now, since I will call these two people,
Principal.
so the inspector of schools. He'll do what he knows, what he can do.
Lordship, if your lordship, just that one status report that has been furnished by the deputy commissioner, your lordship.
Yes.
One ADC has conducted an meeting, your lordship. So may peruse with a bit.
But you see this, no, I'll make a note of that.
Yes, sir.
Here, Mr. D.P. Chalia, the senior counsel, assisted by Mr.
UP Chalia. UP Chalia.
B.P. Chalia, and counsel for the petitioner, Mr. U.P. Chalia. Next one. The Mr. B. Deori and counsel for the you are appearing as government counsel or you are appearing as the engaged lawyer?
Lordship, just I'm checking it, whether I find the column, because sometimes.
Oh, sure, no, Vakaratma is
due to
there.
court
Well,
order.
no, Vakaratma is there.
Yes, sir.
Shanti Chhetri. Okay, Mr. B. Deori and counsel appears for respondent number 1 and has submitted that as per instructions received from the principal of Ahmedabad, HAMIDABAD College, Satsia, SATSIA, the old registers of the college was not handed over by to him by the earlier principal, for which the present principal, namely Sahadat SHAHADOT Ali, had lodged a complaint case before the Court of Chief Judicial Magistrate, Dhubri, on 22/4/2010, which was subsequently registered as GR number 67 of 2010. As the said case was registered, we corresponding to Fakiraganj PS case number which was registered at Fakiraganj Police Station under section 406/408, 420, 468, 506 IPC. By producing a status report in connection with this case, which is prepared by the Deputy Commissioner Dhubri, now it is projected that the district scrutiny committee, on going through various records, did not find the name of the petitioner as in the list of teaching and non-teaching staff. So the documents included, examined included the attendance register, the acquaintance roll, and the remuneration, the record of remuneration. And it is also mentioned in the report of the Deputy Commissioner Dhubri that the screening committee could not ascertain the genuine claim of the petitioner because the principal, Hamidabad College Satsia, could not produce the proceedings book relating to appointment of the petitioner. The petitioners as petitioners. Accordingly, the District Scrutiny Committee, Dhubri, had arrived at a decision that although the contempt petitioners were appointed, but they neither attended the college nor rendered their services as grateful employees since 27/6/1998. Next paragraph. On a perusal of the website of the District Judiciary Dhubri, from the order sheet appearing in respect of GR case number 67 of 2010. The final order dated, just leave a gap. Reads as follows. First line, accused present. Next line, judgment is delivered in open court. Next line, in my considered opinion, comma, the accused found not guilty and hence, comma, accused is acquitted of this case and set at liberty forthwith. Full stop. Next para. Case is disposed of accordingly. And the right side below, you write GMFC. This order is 28/8/2015. In view of the information available in the District Judiciary website of Dhubri, it appears that proceedings of GR number 67 of 2010 has been dismissed with acquittal of the accused persons, the basis on which the District Scrutiny Committee, headed by Deputy Commissioner Dhubri, has relied on the statement of the present principal about the non-production of record. Is left to be more appropriately scrutinized by the Deputy Commissioner Dhubri as the in charge of as the District Scrutiny Committee Dhubri. Next paragraph. Having noted that the personal appearance of the respondents has not been exempted till date, the court is inclined to direct the respondents, namely Sri Hemanta Kumar Rajkumar, the then Inspector of Schools from Dhubri District Circle, from Secretary, District Level Scrutiny Committee.
Lordship. Your lordship permits me. But Hemanta, he is not there. Now the incumbent.
No, he may not be there, but I
Ratul
can
Kumar
only
Das.
direct him to appear. To appear on 26/4/2023. Next, the learned counsel for respondent number 1 submits that the present incumbent is the respondent is not the present Inspector of Schools Dhubri. The learned counsel for the petitioner shall take note of the same. And if so advised, issue notice to the present incumbent of requirement to comply with the order of this court, have an appropriate application for implementing. Next one. The instructions produced are returned based on so for personal appearance. Next for the counsel for respondent number 1. Just before that, you write. Shall send a downloaded copy of this order to the respondents, to the respondent.
Lordship,
Through the-
most
through the-
humbly, your lordship.
Through the office of the Inspector of Schools.
Lordship, most humbly.
Yes.
Lordship, this way or that way, the present incumbent should have to come, your lordship, as per your lordship.
No, you see, that is okay, but the problem I've told you, since we are being complacent, not enforcing our orders, now it has come that even the Inspector of Schools will not comply with the order of the court.
So lordship, let them serve fresh, then accordingly I'll.
No,
the
that is
present
okay, that is there, but I want to,
Because the present is in somewhere, in another district.
no, maybe wherever he is, but he
Yes.
has to come. Otherwise, these officers will not get a message that the court is very serious on implementing its orders. I just want to give a message. Let it be loud and clear to the.
On my submission, if your lordship records the present incumbent's name, Ratul Kumar Das.
No, he'll take these
Yeah.
steps.
Uh,
Just right there where he has stated that is not the present, and the present incumbent is one Mr. Ratul Kumar Das.
And if he is some of.
No, he'll
for
also
addressing
Chari
this
will take
honorable
steps. Mr. Chari will take steps.
Yes.
Uh,
For implementing. Or if you want
He
to
is
implement,
a-
I will issue the.
He's a senior counsel. At times we seek advice from him. We can't advise him what to do.
If you want to implement him as my learned friend has mentioned the date, name, then I will issue notice upon him.
You must give him the notice of requirement of complying with this order. Otherwise, there is no contempt.
But that is true.
Take steps.
Date fix question again, date
26/4.
26. Much obliged, your lordship.
May it please your lordship.
Yes, order has been complied with.
Yes, my lord, on instruction from my, from the petitioner, that is the client, my lord. My lord, that the order has been complied with, my lord.
No, not required, not required. Mr. G. Goswami, learned counsel for the petitioner, submits that he has received instructions to the effect that the order of this court has been complied with, and accordingly his instructions not to raise this matter.
My lord.
Mr. SP Bhattacharya, learned counsel for the respondent is present. Matter since dismissed as not pressed. No,
Closed.
Yes, closed. Having not been pressed, as the order has been complied with.
Deeply.
23.
This is, you can write closed on satisfaction.
Obliged.
Yes.
My lord,
Please, Mr.
This
Malakar.
contempt. This contempt case is on the basis of the mandate. The honorable courts order dated. Let's say 7.
Arrears salary, my lord, 96/2001.
Dated 12/9/70. 12/9/2007. 7 page 7. Well, the dictionary is a employee of an higher secondary school. He was discharged.
Yes, any instructions?
No, my lord.
But the order,
I think I'll get it now. Because as of now, the fresh, no update is available.
the order is at page 7. High Court's order. High Court's order is at page 7. And the decision is at page 13. 19th paragraph.
But you see,
High Court's
you
decision
have,
is at page.
Mr. Malakar, there's
Yeah,
another
my lord,
issue.
my lord.
You see, you have only made this director a respondent contemner. Whereas the main persons who's the this principal and others, you have exempted them. Why? Once you don't proceed against them, why only the director? Without the assistance of others, the director can't release salary. He was a grade 4 employee, right?
No, grade 3 employee.
Grade 3 employee.
Yes,
So for grade 3 employee, who is responsible for salary?
director
But
himself.
if the principal doesn't make the bill
But
and the inspector of schools
He was,
doesn't,
But here one update, my lord. This
was
2019
assistant-
September. The one letter was written by the director to the inspector of schools to immediately submit an area proposal with effect from June 1996 to 2001. I think you're not sure.
No, my lord, the decision of the court is at page 13, my lord.
Yes.
Clear decision.
does it say director?
Yes, director.
Where? Which page?
Director,
It only says the respondents.
yes, my lord.
So if the principal doesn't
Then
make a,
principal, he was working in the office of the principal.
That's what
but-
I'm
but
asking
the
you.
Paying authority is director.
unless the principal makes a bill, how can the director make payment?
The sanction is from the director and the payment is made by the
Okay,
principal.
so you think that the matter, every matter, supposing my secretary is he's an employee, his the what you call the finance secretary or the commission secretary or the what you call law secretary, he will prepare the bill and then it will come down and then the High Court registry will make payment.
Well, the sanction, the amount sanctioned by this director and
Mr.
the
Malakar,
payment is made by the
Have
principal.
you understood what I'm trying to ask you? Have you understood what I'm trying to ask you?
Paying authority.
Who is the person who prepares a bill? Unless the solicitor makes a bill, it will not be sent for payment.
No. In the office of the principal of the higher
So if the
secondary school.
principal has not made it, you have exonerated him, you have not filed this contempt against him.
No, my lord, the authority in the main case, the WPC, there was given.
But in contempt, you are not proceeding against him.
No,
So-
not.
So now, Mr. Malakar, you show me that the bill has been made and sent.
No, my lord, finally the authority is the director, my lord, financial.
Mr. Malakar, please try to understand. This is the 4th time I'm asking you.
I see, my lord.
Without a bill,
Yes.
you just show me that the bill was prepared by the principal and sent to the director. Show me that document.
No, the amount is sanctioned by the director, but payment is made by the principal in the office.
Okay.
Not
Then I am dismissing your this contempt petition. Unless you show the bill prepared, your contempt will not be proceeded with.
Oh, no, that is responsible, principal will be responsible, my lord.
But principal is not a party. How do I know that the bill was sent and he did not make payment?
No, by principal is made party in the.
You see, for a grade, Mr. Malakar, for a grade 4 person
Yes.
salary,
Grade
the
four,
direct-
he is a grade,
grade 3,
grade 3.
this director will not apply his mind.
Yes, yes.
Correct. These are by the DDOs will prepare a bill, it goes to the treasury and payment is made. Every month, you think the salary proposal goes to the director? Every month.
So every month means like these posts.
So every month bill will go to the director.
Not
Every month
every
he will pass, every month
Not
he will
every
get
month.
payment.
The scheme is sanctioned by the director.
No.
And payment is made accordingly by the principal, head of the school, secondary school.
No, where is the requirement that he will have to pass an order for sanctioning? Where is that order? The sanctioning must be made.
Those everything was given in the WPC, my lord. Details was given in the WPC. Sanction was made by the director and the payment was made by the principal. These were given in the WPC, my lord, which was the original case. In WPC, my lord, director, education, inspector, school, higher secondary school, all these were made in the WPC. But after that, payment had to be made by the inspector, by the principal, and through the authority, sanctioned by the money sanctioned by the educational authority. For the payment, mainly responsible is principal. In the main case, all these persons, officers were included in the petition.
Mr. R.K. Malakar and counsel for the petitioner. And Mr. S.P. Bhattacharya and counsel for the respondent. It appears from the order dated 12/9/2007 passed in WPC 8498 of 2001.
Yes, ma'am.
That there was no order for retention of the post in which the petitioner was working for the period from 1/3/1996 to 28/2/1997. Nor such retention is available after 1/3/1997 to 29/11/2001. In the order, it is in the said order, it is recorded that the petitioner was not selected through regular selection process. So nonetheless, there is a direction that the respondents shall release the salary of the petitioner for the period he served in the school from 1/6/1996 to 29/11/2001 by giving liberty to the respondents to adjust the refundable amount due from the petitioner. Full stop. Next, on the next date, in this contempt petition, there's no document to show that the principal of the concerned college had forwarded the proposal for area salary of the petitioner to the respondent, who was the then director of elementary education. Elementary
No,
education.
this is
Assam.
secondary one.
Secondary education Assam. Full stop. In this contempt petition, comma,
At page
annexure,
at page 7.
just wait.
Yes.
Annexure 8 within bracket 1, A within bracket 2, and A within bracket 3. Are the representations for area salary. So how are there's no document so that the bill or of the proposal for area salary was made by the principal of Kalayan, KLAIN Higher Secondary School. Which was received by the respondent and not acted upon. Next, this issue has arisen because of the fact that in this contempt petition, only the Director of Secondary Education Assam has been made a party without naming any person by name. Most of the other authorities, like the principal of the concerned Kalayan Higher Secondary School and the concerned inspector of schools, Kachar District Circle, has not arranged as respondents. On this circumstance, now the petitioner shall produce further materials to show that the respondent had not taken any action despite receipt of the proposal for salary of the petitioner. Next paragraph. List on P5/2023. Mr. Malakar, I have noted in the order, because you see here your contempt petition, it suffers from two things have come to my notice. Number one, that you have as a contempt you have arrayed the office, not any person.
Okay, the petitioner already recorded, send any the letters to every
That is okay. I'm just pointing it out.
Yes.
Number one, nobody in person has been arrayed as contemner. Number one. The second part is that the authority must, what you call, he will receive the proposal and then only he can pass an appropriate order. So therefore, you will have to satisfy the court that proposals were sent and he was inactive.
Well, the case, the WBC case has been another at page 7 in the present case.
I have seen that. That's
Yes,
why I have
my lord.
noted.
Yes.
I have recorded the
Case-
lecture A3,
Yes, my lord.
but that would not give you salary.
The authority who is to be who is to pay? That authority.
No, I have made I have just recorded in my order sheet, but you'll take a call. It will be listed on 3-4 again, 3-5 again. Yes, review petition.
26.
Your instructions have written.
Again,
3-5.
3-5.
Well, this review is of an order passed by your lordship. And your lordship will have a look at the order, which is at page
Where is this Indian Bank
19,
today?
my lord.
Wait. Indian Bank advocate, where is she?
My lord, they have filed the affidavit and we have also filed a reply.
No, but where is she?
Lord, it's difficult at times. She does.
No, you are right, but review has to be heard.
My lord, the basic question, my lord, in the original writ petition, the stand of the bank was that pursuant to the advertisement, no interview was held.
No, you have shown that interviews were held.
Now, my lord, they have come with a reply affidavit saying that yes, since the advertisement was for 19 branches and interview were not held in all the branches, they are not declaring the results. That is the stand in the affidavit. Lordship may have a look at their stand. Firstly, my lord, they are not coming up with clean and clear materials, my lord. First round of litigation, my lord, in the writ petition, their stand was no interview was held. Now, when we brought on record that interviews were actually held on this date, because 5 branches are relevant, so for this writ petition is concerned, and they come up with a stand, lordship may have a look at their affidavit, paragraph 6, page 3.
Yeah, just a moment.
Sorry, sir, I was not aware. Like, remember. Yes.
Where?
My senior is out of station, so she asked for adjournment, my lord.
You see, but this has to be heard.
My lord.
You'll prepare yourself tomorrow. We'll take it up. You can prepare tomorrow.
I don't know, sir, I'm actually not aware of the matter, so.
No, unless you read, you won't be aware.
Yes, yes. can-
You see, even I am not aware of what I am taking up,
Mhm.
but in the process, I am reading it and then I am understanding.
Yes, yes.
Correct.
Yes.
Can you do it tomorrow?
I have to consult with my senior lawyer, so. So what is the
You
matter?
tell her 2 things.
Yes, my lord.
Number 1, there appears to be a change in stand in the writ petition and in this review petition.
Change in the condition.
Correct. She'll be coming when?
I can't exactly say the time now.
No, but there must be some certainty. She is not gone forever.
Actually, she told me about the case in a small way, like she said that
No, I am more interested in when she is coming to argue the matter.
Where has she gone? Where is she now? Out of station? Where?
today she went to Morigaon.
So she'll be coming back tomorrow.
Yeah, of course. I will let her know if the matter is urgent, but from her side, she said that the finance ministry are about to give the reply, but they did not give that reply yet. So she couldn't
But she
stand
won't
on
know
it.
about the ministry. She's for a bank. She won't know about what his ministry is trying to do. Correct.
She just told me that in a simple way, so I'm not aware of what is in the case.
My lord,
Okay, we'll take it up on 5th then. They
Yes.
ask her to be here, right?
Okay, sir. Okay, my lord.
or my lord, tomorrow, because tomorrow is a hearing day.
Tomorrow I have some matters already fixed.
Or can it be on 5th, but a bit higher in the list? I'll just pray for
That I
that.
don't know, but I'll take it up.
Because my lord, the issue is they are part-time sweepers, my lord, and the advertisement is of 2014 and is 2023 now. Recruitment was over, and they are taking. Now, why I'm saying first in the writ petition they say that no interview was held. place these materials. Now they say,
No, I
okay,
understand the urgency, that's why I'm fixing it in 2 days,
well,
but I have my limitations. I
my
can't do
lord,
it.
that is, I just making my prayer and I leave it to your lordship.
Both sides are represented.
Yes.
On behalf of the learning counsel for the petitioner, sorry, respondent, Miss, your name,
Marilyn,
Marilyn, prays for adjournment on the ground that the council holding the brief is out of station. That's right. In view of the changing stand, which appears from the affidavit in opposition of the respondent, then what was pleaded in the writ petition, let this matter be listed again on 5/4/2023. The prayer for adjournment would, on behalf of the respondent would not be considered of this date.